Okay, never mind.
What's that?
I was gonna ask if I was able to get a paper for community service to pay towards my fines, because I did a day at the dog pound also, but I don't know if I got credit for it, 'cause
Check with Mr. Did you get credit?
I'll have to look on. I didn't see a name when I was checking. I was reading that.
All right, so.
Rest in the courtroom, have a seat.
That's correct, Your Honor.
Everybody has to be seated.
Okay, it says you're compliant, so very good. Yes, you can do community service, and usually the dog pound will report it in, you get credit, $50 for
Okay.
whatever days you've done.
do I need a paper to take with, okay,
Yes.
okay.
Mr. Cooper will help you with that. Mondays or Fridays? Either?
Yeah,
August 7th, that's a Monday, 9 o'clock.
thank you, Your Honor.
You're welcome. Clarence Falk is not here, it's not finished. Leah Warren. Mamie Mullins is not here. Get some more. Tina Wells.
Here.
Is here, 14/12/76, 13/6/88. So you just have fines to pay. Do you have a payment today?
No, I did do one-day community service toward my fines. I'm gonna do,
That is correct, Your Honor.
Okay. I'll set you for August 7th also. August 7th, 9 a.m.
okay, thank you.
You're welcome. Over your heart. Yes, here. Is that Minda Reeds?
I no longer go to Mender Reed, Your Honor.
Okay, it says you are compliant with what you're supposed to be doing. Can you make a payment on your files today?
$30.
All right, see the clerk to make your payment, and I'll set August 7th as your next hearing.
Thank you.
August
Thank you.
7th, 9 o'clock. Sherry White. Sherry White's been called. Case number 13-1025. She hasn't done anything on it, so it'll be a warrant issue. Debbie Eastern. Debbie Eastern's been called 22-786, 13-2792, 12-921. She still has lots of stuff left to do. She'd be a warrant, not appearing.
Matthew Gonzalez, James Helton, Trevor Hodge, Jennifer Losey, Charles Martin, Whitney Morris.
All right, Matthew Gonzalez is here. 22-377, 22-362, 22-343, 22-309, and 2277. How are you, Mr. Gonzalez?
Fine, Your Honor.
Congratulations, I followed your other case from afar.
Thank you, Your
So I saw
Honor.
what happened
I appreciate
with
it.
that. So that's a good result for you.
Yes, Your Honor.
What can you do on these? Is there anything? you can
Yes, I was
bring to
prepared to
pay?
pay earlier, but they already took the file, but I'm ready to pay here in a little bit.
How much are you going to pay?
I have $10 at the moment. I'm trying to find work and trying to rebuild.
Okay, I understand. You can do community service and get credit of $50 for every day you do. Any day but Sunday or a holiday, you can work community service.
Yes, Your Honor.
I'll set you for August 4th, that's a Friday,
Yes, Your Honor.
9 o'clock.
Yes, Your Honor.
Okay, see you first.
All right, thank you.
You're welcome. James Helton. He's at Bethesda. Okay, rocky start, and are you on board with treatment, Mr. Helton?
I mean, I'm on board with it because I need help, but we just bought our own trailer, paying payments on and a vehicle, and the program I'm in now, it takes 6 months to get to work, and I had talked to Lawrence County Recovery, which lets you work after a month, and I was hoping I could try and see if you give me a chance for that, just because I don't want to lose everything I've worked for in a year, you know. And I've had the same job for a year, which my boss is offering me to come back to work still, but within 6 months, he
Who's
says,
your boss?
Kevin, it's Quality Inn Motel. I'm the maintenance man.
Oh. Well, I take it, I remember his tests at the initial tests were like blew up everything. You tested for just about everything we can test for, including fentanyl.
I didn't feel for the only thing I did was meth, but I mean, which was a mistake. Like I said, I do need help. I just don't want to. Well, I got a trailer payment, a car payment, and my fiance's out there on her own now paying for it. And like, I do need help. I'm not trying to get out help because it would have progressed into something worse. I'm just trying to get something that'll let me work and pay my share of the bills so we don't lose.
Your Honor, the concern also is that the day that we took him into treatment, he had just left RRS and there was meth found there, and he tested positive for methamphetamines, benzos, amphetamines, and MDMA. So I don't think that he understands the severity of his addiction. I understand that everybody wants to work and they need to, save things and all that, but he's not going to be able to save it if he can't get better.
Yeah, and that's right. And like I said, I mean, I'm willing to do that program, but like Lawrence County Recovery just lets you get to work faster, but it's still the same thing, and that's all I'm trying to do.
I don't think, well, you did not test positive for fentanyl, but you tested positive for 4 things. Okay, I want you to stay where you are. I don't think if they knew, I don't want people poaching off of other providers, so I don't know what their story is going to be. Maybe they didn't know that. I don't know what the situation is, but I want people to stay where generally stay where they are, not go to other providers.
All I'm saying, Your Honor, is like my trailer, my car.
And I've already heard you and said no. So there's your answer. No, you're going to stay where you are. That's where you need to be. The other option is jail. And I'm assuming you don't want that. All right?
Yeah.
August 4th will be your next hearing. 9 a.m. Your name, ma'am?
Jennifer Losey.
22 216.
Your Honor, she just turned in 2 days community service.
Okay, very good. And you made a payment, a pretty substantial payment in
And
June.
I'm making my 180 payment today as well.
Okay, very good. Put you down for that. And are you getting treatment anywhere now?
No, I'm working currently.
Okay.
I work midnights.
Because you had been going to the Spectrum and they're out of business now.
Yes, and I was going to Shawnee, but last court hearing I was here, my PO told me to contact them to see what was going on, and I did, and they have dropped me.
Shawnee dropped you?
Yes.
Okay. Well, just to give me a baseline, I want you to go do a urine screen.
Yes.
Come back. So let's
Yes.
see where you are.
Okay.
Trevor Hodge. Call for it has not appeared. He's supposed to be going to ProAct. I assume we've got nothing from them. So he gets a warrant. Charles Martin, 22416.
Mr. Martin's in our sober living. I think he got his dates mixed up. He went to work today, but he's compliant with all treatment recommendations.
Okay, I'll give him a pass and just set another date for him. Let's make it the 24th, July 24th, these next hearings.
Thank you, Your Honor.
You're welcome. Whitney Morris. Whitney Morris is 222575. She was actually scheduled last Monday. She called and said she couldn't get here due to some issues, and I continued it for a week to give her extra time to try to get in. She's still not here, and she hasn't finished her community service, so she gets a warrant for not appearing. Okay, that finishes the reviews. We're going to start the arraignments, which are new cases, and we have several here. Yeah, we've got a few here, then we've got several at the jail. As I said, the jail is very crowded. A lot of new cases, people at the jail. We'll do those by teleconference. So for those of you who are here and have a new case, listen up. I'll explain your rights, which you've heard many times before if you watch any criminal shows on TV, because they always talk about Miranda warnings from the, it's not a right that the Supreme Court has overturned yet. You have a right to be warned about your rights from a case called Arizona versus Miranda. You have a right to remain silent. You don't have to say anything when you're in court on a criminal matter. If you do make statements, though, what you say is all on the record. It can be used against you if you admit something that's damaging to your case. You have a right to have an attorney. You have a right to have one appointed if you can't afford one. You have a right to bail. You have a right to make the state prove any charge against you beyond a reasonable doubt. Those are the rights that all defendants have. If you enter a guilty or no contest plea, you're waiving those rights that you have. You should not do that if you don't understand what's happening, if you want to talk to a lawyer, if you want a trial on your case. You should enter a not guilty plea. That's the safest plea you can enter. You can always change it later if you decide, well, it would be good for me to enter a guilty plea. You can decide that later after you talk to a lawyer if that's what you want to do. But if you don't really understand what's happening, don't enter a guilty plea just to get it over. That's not a good reason to enter a guilty plea. Call the first case.
State of Ohio versus Brandon G. Helton, case number CRB 2318, TRD 213585 A and B, TRD 213053 A and B.
All right, Brandon Helton, and looks like you had a review hearing last week that you didn't appear for?
Yeah, I was thinking it was today, and then I found my paper over the weekend.
Okay, and you still have some community service to do?
Yeah, I've been working a lot, but I've got days scheduled that I got off to do. I have the next 3 Thursdays scheduled off, and then
Is that correct, he's been working? No?
like at my job, I've been working.
Your Honor, if I may, he missed a hearing. On May 22nd, he was ordered to do some community service, and he hasn't been here since then.
What do you say about that?
I've been working 7 days a week, 65 hours a week. And when I'm not, I'm a single father. But like I said, I have
I'm
days
going to order you
scheduled.
placed in custody then. You violated court order, so he's to go into custody this time.
There ain't no way to work around it.
We'll talk about it later after court, after we get through these other folks.
State of Ohio versus Jared Monroe Rodman, case number TRC 212826 A, B, and C, CRA 21597, and CRD 21598. Jared Rodman.
Jared Rodman? Jared Rodman.
Jared Rodman.
Okay, he should get a warrant. Folks that if you have an arraignment, you need to be in the courtroom now. Not out in the hall, not outside the court. Are you Jared Rodman?
Yes, sir.
Case number 212826, 21597, and 598. Looks like you missed a pretrial back in January of 22, and your attorney was Mr. Steyer.
Yes, sir.
We need Mr. Steyer in the courtroom. Is he in a treatment facility now?
He is. He's with Southern Hope.
Okay.
I
Probably don't need to say anything. Mr. Steyer would probably like for you to just talk with him before you put anything on the record. He has a pending OBI and a pending, well, there's an F4 disrupting public services.
Okay. Your Honor, we have a report here from Southern Hope showing what's going on in terms of his progress and what he's been tested for.
I want you to go take him out in the hall and talk to him, and then we'll have him back.
Okay. So go ahead and pass this forward.
You're ordered not to depart the courthouse
Yes, sir.
All right.
until you come back before the court.
Thank you.
It will be recalled.
State of Ohio versus Brian W. Webb. Case number CRA 2832, TRD 2761, TRD 2015-55, TRD 2135-14, A and B.
Hello, Your Honor.
All right, Mr. Webb, it's the last you missed a hearing on last Friday, I guess it was. For review, is that correct?
Yes, Your Honor, I'm a dates, I was thinking it was today.
Okay, I want you to go do a urine screen and come back after you do your urine screen.
I think they put it in preliminary, it's not extended.
Okay, so Mr. Morford. Let's have Mr. Morford come in the courtroom, please. Mr. Morford. Okay, whoever's talking on teleconference, please mute your microphone. Mr. Morford, your client Brian Webb came in I told him to go do a urine screening. He missed the hearing last Friday.
I spoke with him as that came in, Judge. I
Okay.
saw him.
We'll recall him after he does it, we get the results.
Okay, thank you, Judge.
Just want to let you know. Okay. Okay, we're starting some pre-trials and then we'll go to the jail for arraignments.
State of Ohio versus Stephen Dodgen, case number TRC 23457, A, B, and C.
All right, Mr. Dodgen, do you have an attorney?
Yes.
Who is
Yes, Your Honor. Jeremy Dodgen.
Okay, is he here?
No, sir.
Okay, how's he gonna represent you if he's not here?
He told me to just come up and talk to you and that we would have a continuance happen or something like that.
You know anything about this, Mr. Hill?
Well, I don't, but I know Mr. Dodgen and his brother, the attorney, and I know that he's generally very responsible. He practices in Columbus, and so I don't know why he wouldn't be here today. I wish he had called me because I would like to have talked to him about the case. We don't have a problem with it being continued.
Did he give you a date when he can be available?
No, sir, he did not.
Well, how do you expect me to proceed with your case when I don't even know when your lawyer can be here?
I've never done this, sir. I don't know.
Well, I assume since he's your brother,
Yeah.
that you have him on your phone.
Yes, sir. I tried to call him before I came in.
Well, go out and try to call him again. We're gonna be here for a while, so I want a date when he can be here.
Yes,
So
sir.
you go get him on the phone, get me a date. It's gotta be a Monday or a Friday.
Yes, sir.
We'll recall your case.
State of Ohio versus Jamil Santiago, case number TRC 23528, A, B, C, and D. Mr. Haslett.
Mr. Haslam's case set for pretrial. This is the case that we discussed in chambers this morning.
Correct, Your Honor. Pursuant to our discussion, Mr. Cruz Santiago is willing to do what has been suggested. We'd ask.
Now, he'll have to go to an out-of-county, there is no in-county treatment program anymore.
Yes, sir. He is absolutely willing to do that, so we would waive time for the period of any continuance necessary for him to complete the DIP school.
Can he do, I think the next one in Scioto County is August 11th, I believe. I don't know if they have available spaces.
We'll confirm his availability for that, Your Honor.
So you want to come back, say, end of August? That would give him enough time to get that done?
Yes, Your Honor.
He can go, if he wants to go to some other location, I have no problem as long as it's a 3-day program certified by the state of Ohio. What's your schedule like toward the end of August?
Looking right now, Your Honor. Your Honor, I'm open August 25th right now.
Okay, August 25th at defendant's request for a pretrial at 10 o'clock.
State of Ohio versus Tyler Wellman, case number TRC 23316, A and B. Tyler Wellman.
Tyler Wellman is also Mr. Haslam's case.
Your Honor, I am not aware of where Mr. Wellman is this morning. In reviewing my notes after I arrived and saw that he wasn't here, I'm not sure that my staff notified him of the court's decision. Therefore, we would ask to continue the matter, get time waived for the period of the continuance so I can make sure that I get Mr. Wellman here.
What date would you like to come back?
Your Honor, I can come back Friday the 14th.
That's fine. At defendant's request, case is continued to July 14th for a pretrial, 10 o'clock.
Thank you, Your Honor.
State of Ohio versus Russell A. Daniels, case number TRC 23501.
Mr. McCown's case set
Yes,
for
Your Honor.
pretrial.
Yes, Your Honor.
Your Honor, at this time, we would ask for a continuance. I spoke with Mr. Hill, we spoke about this in pre-trial. He is doing exceptionally well in recovery. They indicated that he should conclude it within the next 30 days. So we would ask until August 14th, if that would be okay with the court's record, and of course, wait time.
All right, at defendant's request, case is continued to August 14th for another pre-trial, 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Garrett Monroe Rognon, case number PRC 21-28-26 A, B, and C, CRA 21-597, CRB 21-598.
All right, Mr. Stiers' case, there's been failure to appear for quite some time, over a year. Mr. Rognan appeared today, has placed himself in Southern Hope for counseling, and I believe I saw in the file, he had been at another facility before.
He was at New Life for a period of time. Due to some scheduling issues with his job, Southern Hope was a better fit. He moved there. He's been there for about a week at this point, but he's been in treatment continuously since April. He said that he's asked for New Life to send paperwork into the court. I'm not sure. He said something in the file, so you may have received that, showing where he'd been in since April. Basically, he came back down here and started treatment, became aware of the warrant, and presented himself here today. I don't have my file with me. Obviously, this is a couple years old case. So what I'd like to ask is if we could have Mr. Rognan put back on the pretrial docket on a fairly soon date that's convenient to the court. He is in treatment at this point, so I think basically allowing him to continue with treatment while we regroup and figure out what's happening on these cases might be the best solution to the situation that we have.
What's the state's position on it?
We're not opposed to Mr. Stiers' suggestion.
All right, I'm looking at the 14th.
14th of July. I'm here that day, Your Honor.
July 14, and I know there was a representative from Southern Hope here. It's in the back there. I'd like to have a report then. A written report is what he's been doing in his treatment. So there'll be a pretrial then, July 14th, and actually a preliminary hearing also, because there is a felony in this. So this will be your last, you've had a mess up, and you're getting another chance, but this will be the last one as far as staying in this court. If you mess up again, I'm just going to tell the prosecutor, take it to the grand jury.
That's all I need.
And then you'll have a felony, you'll be in the other court, and you'll have to deal with a different judge, which may be better for you, I don't know, but then you have a risk of going to prison. Stay here, you don't have any risk of going to prison.
Yes, sir.
So do what you're supposed to do, no excuses.
I
July
agree.
14th.
Thank you.
Be your next hearing,
Thank you.
10 o'clock.
State of Ohio versus Amy Atkins, case number TRC 23709 A and B.
It's an old case.
All right, Amy Atkins.
She's mine, Judge. She is in treatment.
All right, this
In
is
West
Scott's
Virginia.
case at Lotus Recovery Center.
That is correct, Your Honor.
All right, I see Ms. Atkins is appearing by teleconference. Can you hear me, Ms. Atkins? I can't hear you. Well, see, I may have you muted. Let me see if I've got you muted. I do. Let me turn on your microphone. Now, Ms. Atkins, can you hear me?
Yes.
Okay. How are things going?
I'm still in treatment, and my graduation date is the July 18th. I'm completing everything I need to complete, and then some if I need to. But I'm still here.
Where is here? Where is this facility located?
Lotus Recovery Center. It's in Comfort, West Virginia.
I remember that now.
It's a facility that specializes in alcohol addiction and issues.
Madison County. Right, Madison County. West Virginia?
Boone County.
Boone County. Madison is the county seat.
Yes.
Okay. Well, so you should be available to appear in person after, what'd you say, July, what? Is your 14?
No, 18.
18, okay.
Yes.
All right, after that, what's your availability, Mr. Scott?
I will not be available
I'm sorry.
again until the 14th of
You're going to be
August.
on orders, right?
That's correct, Your Honor. I'm already here the 14th, if you want to set it for
Yeah.
then.
Okay, Ms. Atkins, I'm saying your next hearing for August 14th.
Okay, thank you, Your Honor.
And you have to be here in person at the court in Chesapeake.
I sure will.
Okay, all right, August 14th, and also tell the folks there at Lotus Recovery, I need a report from them as to what you're doing.
Okay. I will
Mr.
do
Hill.
that. He's listening.
Your
Now,
Honor,
where does he need to?
You can just give it to your attorney and he can submit it to the court.
Yep. You have my contact information, get a hold of me, get it to me, and I'll take care of it.
Yeah.
Your Honor, this is an OVI, and so at our next hearing, we want to know whether they want to contest the case or whether she's willing to go ahead and plead guilty. If she were to plead guilty at this point, we would be agreeable if she completes her counseling, her residential treatment, that we would ask the court to let that stand in lieu of a 3-day driving school.
Okay. All right, August 14th, we'll need a decision whether we're going forward on a legal challenge to the case or whether there'll be a plea.
That's correct. Yeah, I'm still waiting on discovery on this one, Your Honor, but I
Okay,
can't imagine
so that
anything.
you should have that by then.
Absolutely.
August 14th is the next hearing.
Thank you, Judge.
You're welcome.
Thank you.
State of Ohio versus Christian Bradley, case number TRC 23566, A, B, and C.
That one's mine too.
Mr. Scott's case set for pretrial.
Class, no, but I've done like, I've been there like 5 or 6 times, yes. I've done the assessment, I've done an intake, I've met the doctor, I've met the financial people.
When you go back next.
I was supposed to be there today, 11 to 1 for my first class, but I'm going tomorrow. So yeah, I rescheduled it.
Beautiful. So Mr. Bradley, OVI, first offense. Last time we were here, State and I discussed, he is in ARC Treatment Center. He's doing what he needs to be doing. He's had roughly 5 classes so far. He's done the intake. He was supposed to be there today, but because of court, he's going tomorrow. So I believe the plan is to continue his treatment and we revisit
I mean, I
accordingly.
can show you my schedule too, if that helps.
I believe you.
No, I was just saying. Yeah.
All right, so we'll make it August 14th also.
August 14th, absolutely.
And we have a
Is my
report
license
from
guaranteed still
Mark.
in play though?
He did come in and get assessed, and he's been compliant thus far. It's still very early, but he's done everything he's needed to do.
Okay, very good, thank you.
This is a first offense high score, so if we are going to be asked to take his counseling into consideration as far as what our recommendation of the court's going to be, then we would want there to be a plea and delay sentencing, allow him to complete his treatment. So if they're not ready to do that today, we want to know the next time we come to court.
We're going to wait till August 14th to see how treatment goes from there.
All right.
I imagine by then we'd have a change of plea ready.
All right, August 14th will be the next hearing, 10 o'clock, pre-trial.
Come back then. Okay.
State of Ohio versus Vanessa Bryant, case number CRB 23372.
Hi there. How's it going?
This is Mr. Scott's case set for pre-trial.
Your Honor, there's a cross-filing with Clarence Mayhem.
Mayhem?
Yeah.
Clarence Mayhem. That's Mr. Smith's case, right?
Yes, Judge.
State of Ohio versus Clarence Mayhem, case number CRB 23370 and CRB 2988.
Mr. Heald, how's the state want to proceed?
Well, the cross-filing is a matter, I guess, we want to hear from each of the attorneys for the defendants as to how they want to proceed. We have protection orders in place now, and so we don't know whether they want to continue those or not, or whether either one of them wants to. We also, Your Honor, on Mr. Mahan, have a 2020 case that's still pending.
Right, assault charge, and then he's got a conviction from a traffic matter from 21 that he hasn't done anything on.
I wasn't familiar with that, Judge, but I am familiar with the ones with Goldie Stapleton. One time that was dismissed because she wasn't cooperating with the prosecutor. I guess now she's wanting to cooperate. If that's the case, I'll need to file discovery and come back on that one. I'm not sure. I mean, we could deal with this. They're separate cases.
Well, I'll point you on the traffic cases.
Okay.
21187 is the case number, was a driving under suspension. He had 3 days of community service and fines and costs, and my record shows he hasn't done anything on it. He has a bond,
And on the 2020 case, Your Honor, we're going to ask for protection order.
Is that on the Stapleton, Goldie Stapleton?
Yes.
Okay, so on 2988, is there any problem from him staying away from Ms. Stapleton?
There's not, Judge, no.
Okay, so I'm going to order that. He's not to go around her, contact her, post anything about her while this is pending. That's Goldie Stapleton. Then with the case with Ms. Bryant, how do we want to proceed on that?
I just spoke with Ms. Bryant. There is a CPO currently in place. She represented me that she wants that to continue, but she's not necessarily interested in pursuing anything criminally against the accused.
All right.
That being the case, and I don't know how Mr. Mahan feels about his part as a victim, but we would suggest a 90-day continuance on each of these, and if there are no further problems, we would be agreeable to a dismissal upon the payment of court costs, and probably one court cost would be sufficient.
I just spoke to Mr. Mahan about that. He's fine with that on this one case.
Okay.
Correct.
Who's going to volunteer to pay the court costs? Don't everybody speak at once.
I nominate Mr. Scott Klein.
I volunteer Mr. Mahan.
That'd be fair, 50-50?
50-50.
But it's going to be paid on one case. So-
Yes.
So somebody needs to come up with half. It's going to be $135. So split.
That's a $90. He can bring $62.50 in with him on whatever that 90-day date is.
Okay, so it's actually going to be 160. So make it easy, clean, 80.
I can do the math on that.
$80 each. So it'll be a $25 sign counsel fee on each, and then one court cost. Let's put it on Mr. Mahan.
Fine, Judge. Why not?
I'm old school. Yeah, I have to pay. I'm
He's-
Mr. Davis, so he's today.
He says as long as he doesn't have to pay today, he's fine, he'll do it. So we're good with that.
Okay, so let's pick a date for those. That's going to be October 3rd. If you're available, that's about 90 days.
I will be here, Judge, Tuesday.
I will be here unless my brother has a 50th birthday
I'm
party.
sorry, October 2nd.
Oh,
I gave
second.
you the wrong day. October 2nd.
I'm available, Judge.
I'm available also.
And from now on, you need to just tell me, that's the wrong date, Judge. That happened once before. It's got to be a Monday or Friday, or unless it's a holiday, then it could be Tuesday. So October 2nd. 90 days with one cost. Split.
And no further problems.
And no further problems.
And we'll need a new date for the
Yes.
other case, the 2020 case.
And I'll file discovery today, Judge, so
About a month?
I'm here the 7th or 14th of August.
Let's do the 7th.
Okay.
And it would be a good idea if you started working on these old cases.
I was going to suggest that. You should talk to Josh, make
He's already sentenced. August 7th will be the next hearing for Mr. Mahan on his two other cases. Anything else? That's all.
State of Ohio versus Cody and Perky, case number CRB 23319. Cody and Perky.
Judge, he is also mine. Mr. Perky is in Lorraine Correctional in Northern Ohio. He's in prison. He had his APA revocation hearing, so that's why he's there. I've been trying to get all of his PO and LCI this morning to get him on video. I believe the state and I have this resolved. We're just trying to get him physically present to get this taken care of.
You want to keep working on that today, or you want me to?
I will keep working on it. If it's not looking good in about an hour, hour and a half, I'll send a message up.
All right, this case will be recalled later in the docket.
State of Ohio versus Rebecca A. Williamson, case number CRB 23382. Rebecca Williamson.
Set for pretrial.
Pretrial, this one is a DV action, husband and wife. Obviously, she's wife.
Is there a
Oh, is it-
co-defendant?
Donald Williamson is the
Donald
cross.
Williamson.
I'm tracking that he's in RSS currently.
Okay. Does he have a lawyer?
Mr. Holt.
Yes, Mr. Holt. He wasn't here just a few minutes ago. I don't know if he's here now or not.
Now, pressure on her.
Yes.
State of Ohio versus Donald Williamson, case number CRB 23384. Holt's not here.
Oh, he left the program against advice. And he just had an OR bond up, so makes it easy for him. I assume you want a warrant?
Yes, Your Honor.
Has he contacted you then? He has an order to stay away from the TPO, so if he does come around, you should retreat and call law enforcement.
Yes, Your Honor.
There'll be a warrant issued for Mr. Williamson. Continue August 14th.
August 14th.
And Ms. Williamson's case is continued August 14th, when Mr. Scott will be available. Thank you for the report.
Hang out in the lobby, I'll check. Okay. You want to have labor on this bill?
Yes, please.
State of Ohio recalls Brian Webb, case number CRA 2832, TRD 2761, TRD 2015-55, TRD 2135-14, A to B.
This is Mr. Morford's case. Okay, that's a a good screen, send you this screen, and it's appropriate. So are you still Family Medical?
Yes, I'm also Shawnee. I'm also going to Shawnee,
Oh, Shawnee.
both of them, yes.
Well, I don't have a report from Family Medical.
I asked her Friday to send you one.
I used to have a person here. They used to have a liaison that came to court, so we could get reports pretty easily, but that has stopped. So I don't know what the issue is there. We've been at this for a while. What's the state's position?
Well, we have been at this for a while, a long while, and I know that Mr. Webb's made significant recovery over that time, and I apologize because I
You probably don't have your file
don't have
today.
the file this morning.
It was actually set for the 30th.
That's okay. Well, if he's made if he's made enough of progress in order
Well, I'd like to have a report from, before we conclude it. He still has some other things unrelated to substance use that he has to take care of. There's some traffic matters that still need to be, well, one of them's not even completed. It's still pending, a driving under suspension. So what's the status of your license? Are you working on that?
Florida's got them tied up. I gotta go to Florida to
Okay.
get them released.
Well, we're gonna have to resolve those two. May just have to enter a plea, I don't know, or we can set up for a trial. It's hanging out there unresolved. That's case number 213514. So driving under suspension and a failure to control, so it looks like there was a wreck. And there was no proof of insurance. It was a one-car accident. Yeah.
There's also TRD 21-50-55 of this resolvement to the U.S.
Okay. Yes. 1555 is unresolved also. It was, and it's a driving under suspension.
Looks like there's 3 traffic cases that are resolved.
2761 too.
761 isn't resolved. 14.
Also a driving under suspension. You want to do those today, or you want to put it off?
Judge, we're prepared to go with it today, and I believe Mr. Hill and I got an agreement to present to you for your approval.
Okay.
He's going to change the plea to guilty, Your Honor, to the remaining traffic citations. And I believe Mr. Hill and I would ask you to suspend any jail time. We've been through it with Mr. Webb, and he has, I won't say earned it maybe, but I would ask you to take into consideration the progress he's made from the time he first appeared here in front of you to today. And he does not have money with which to go to Florida and take care of his license now, so and I don't see him having it in the near future, so we'll go ahead and get those off your docket, Your Honor.
All right. Anything else you want to say, Mr. Webb?
No, Your Honor.
Okay. I will say that I know you've been with me on and off for a while.
Too long.
But as a compliment, I'll say this is the best you've done. I gotta give you some, I give you some kudos there. You're doing better now than you've done in a long time.
I feel better.
And I mean, it hasn't been a straight line, which that's usually the way life is. It wasn't from here straight up to where you are now. There were some jags along the way.
I appreciate
that.
that.
You keep going up, and I hope you continue on that path. You're getting a little older and smarter now, I hope.
Older, yes. Smarter, definitely.
Well, some people just get older. They don't get any smarter, they just keep making the same mistakes over and over. But I see some improvement with you.
I appreciate
And I want you to know that I saw that, so, and I appreciate it.
Well, I'm working hard. I'm working now, I'm working hard.
But you need to keep doing that.
50 hours a
You gotta
week.
keep working at it. It's not like just falling off the log. You just can't wake up and say, okay, what's gonna happen to me is gonna happen to me. Well, that's a recipe for disaster. You gotta say, okay, I got a plan, and I'm gonna stick with my plan. And when I get tempted to go back to my old ways, I got a plan to keep me out of that.
I do. People, places, things, it's
Right.
what it boils down to.
Yeah, because those old people, if you go back around them, they're gonna pull you back in.
I'm sorry, I missed
I
that.
said, if you go back around the old folks you used to hang around with, they're gonna pull you back into where you used to be. That's just what happens. So you gotta avoid that. Okay, so what I'm gonna do on, let's start with, what have you got? 2761 is the oldest one. I'll just, in light of you doing so well, I'll just impose a $20 fine in court costs on your driving or suspension. And then the next one is 213514. Same thing, $20 fine, court costs. There was a failure to control. Was that your car or somebody else's?
Well, that's mine.
Okay. I won't even impose a fine on that. That's because you wrecked your own car, so that's penalty of itself, and you'll get another suspension from the B&B on that one because you didn't have proof of insurance, so that's enough of a penalty on that. Okay, then 2015-55 was a driving under suspension, $20 fine on that.
You want to review or final pay?
Let's just do a final pay date of October 10th. You've got till October 10th to pay those. If you don't pay them, then we just send it to B&B that you didn't pay, and they'll do another suspension. So you'll have like 5 suspensions. I don't know how many suspensions.
I'll have taken full. Is that 3 separate court costs on these, or?
Yes, each one has a.
I'll just make sure.
I think that's fair.
Oh, very,
Each one's
very.
a separate incident.
Yes, sir. Very fair.
So now, on your CRA case number, let's go another month, and I need a report, and I'll send a text when court's over to my old.
Stephanie's my counselor, if you want.
Okay. I don't know her, but the person that used to come here, I think is still at.
Yes, Kendra.
Yeah. I'll send her a text, and usually if I send her a text, then she'll get a report done, so August 4th, let's come back then.
August 4th.
On that case, and that'll be a preliminary hearing. Okay.
Thank you so much, Judge. Appreciate it.
Thank you, Judge.
Thank you, Mr. Bill.
Okay, we've got a couple more arraignments.
State of Ohio versus William E. Mann, case number CRB 23395.
William Mann. Sir, you're William E. Mann? Yes. Mr. Mann, you have a domestic violence charge filed against you. It alleges that on June 30th, you knowingly caused or tried to cause physical harm to Treese Smith, and that Treese is either a member of your family or a member of your household. So that makes it domestic violence. Maximum penalty is 6 months in jail, $1,000 fine. You understand the charge?
Yeah.
You understand the rights you have as a defendant? How do you want to plead to this charge?
Not guilty.
Do you want to be considered for a court-appointed lawyer?
No.
Are you going to hire a lawyer?
No.
Okay.
Your Honor, if it pleases the court, I've spoken with Ms. Smith, the alleged victim in this matter, and she reports that Mr. Mann and her do live together, and I think she intends on continuing to, and it was our suggestion to her that maybe some counseling might be in order, given the circumstances here. And I suggested to her that maybe she could take part in some counseling, they could do some relationship counseling, and she was in favor of that. So I don't know whether Mr. Mann would be or not, or whether he's going to ask for an attorney also.
Well, he didn't ask for a lawyer, so, but she doesn't want a protection order.
She does not want a protection order.
All right, Mr. Mann, are you agreeable to getting some counseling? And I assume then, I'm reading between the lines, the state would dismiss the case if he did some counseling successfully?
I believe so, given the current, what we know at this point, and the current circumstances with Ms. Smith wanting us to not have a protection order and for him to get counseling. So we would probably agree to that. And we would want to also know where they're going to get their counseling. And
is that anything that interests you, sir?
Yep.
Okay. How do you pay for medical services?
I've got a medical card.
You have an Ohio medical card? Okay, and you live in Proctor?
Yes.
RRS is in Chesapeake, so that's probably the most convenient place for you to go. And I think it's a good idea if you both went together. I can't order you to go. I can order him to go, so I'm going to order him to go as a condition of bond. I'll let you sign a signature bond. Oh, you got a bond up, so your bond's continued. But I'll make it further conditions you go to some counseling. Mr. Gwynn is here from RRS, and he'll talk to you about getting that set up. And then let's come back in about a month and see where things are. Okay? Are you employed, sir?
Yes, sir.
What's your work schedule?
40 hours a week.
Mondays and Fridays, through Friday, so
Monday through Friday.
it's going to have to be a Monday or Friday. Does it matter to you which day it is?
I'm big on Friday.
Friday's better? Okay. Let's make it August the 11th. That's the second Friday in August. You've got to have a hearing here. And the good thing about RRS, they will prepare a report, so you don't have to worry about making sure they get you a report. They'll give me a report as to what's going on with you. I want you to speak with their representatives in a red shirt. He'll walk out in the lobby with you, get you set up. Do you have any questions, sir?
No.
Okay. Next hearing is August 11th, 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Michael B. Anderson, case number CRB 23394.
Sir, are you Michael B. Anderson?
Yes.
Mr. Anderson, this is a domestic violence charge also, and it alleges June 28th in Fayette Township, you knowingly caused or tried to cause physical harm to Portia Anderson, that she's either a member of your family or a member of your household. That's a first-degree misdemeanor. It carries a maximum penalty of 6 months in jail, $1,000 fine. You understand the charge, sir?
Yes.
You understand the rights you have as a defendant?
Yes.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes.
Do you have a job?
Yes.
What do you do?
Work for RRS.
Oh, okay. Are you paid by the hour?
Yes.
How much per hour?
13.
How many hours a week?
40.
Do you have children you're supporting?
Currently, yes.
How many?
I've got one in my care, but I got 5 altogether.
Okay, you're eligible for court-appointed counsel, and Mr. Stratton, I'll appoint you.
Yes, sir.
Enter a not guilty plea.
Yes, Your Honor.
Is there a protection order request to you?
We haven't spoken with the alleged victim in this, but we'll ask for a protection order until we know otherwise.
Is it a problem for you to stay away from Portia?
Well, kind of. She's living at my mom's house, and that's where all my kids are.
But you haven't been living there?
No, she was living with me, and then when this happened, she went to my mom's house, and we've been apart since.
Do you have a contact number for her?
I'm sorry?
Do you have a contact number for her?
Not now.
Okay. Because I would have the prosecutor try to call her if you thought she would not want a protection order.
We have a number for her, Your Honor.
You want to try to get in touch with her? Okay, we'll recall this. I'll let you talk to Mr. Stratton. We'll recall and decide whether there will be a protection order after the state's trying to get a hold of the complaint party. All right, thank you. You're welcome.
State of Ohio versus Trevor Dement, case number CRA 23-380, CRB 21-167, CRA 2630, CRA 2321, CRB 2322, CRB 19667, CRB 19570.
And it looks like we've got a new charge. All right, CRA 23-380 is new. You are Trevor DeMille. It's a domestic violence charge. It's alleged that June 17 of this year in Fayette Township, you knowingly caused or tried to cause physical harm to Cassandra Hurd, who's either a member of your household or family. And it's alleged you've been convicted of domestic violence on 2 prior occasions. So that's why it's a felony. Felony 3 carries a maximum penalty of 5 years in jail and an $8,000 fine. I have a report that when I was texted that he would have this. He's got a report from OVP saying he's entered their inpatient recovery program and is compliant with their requirements at this point. All right, do you understand the new charge against you, Mr. Mint?
Yes, sir.
Do you have the money to hire a lawyer?
No.
And you're unable to work now that you're in treatment?
Yes.
I'll appoint Mr. Steyer to represent you. What's the state's position on bond?
Your Honor, the state's not opposed to an OR bond. The alleged victim has contacted us, and she does not wish to have a protection order.
Okay. No protection order at the victim's request. I'm going to let Mr. Dement sign a $2,000 signature bond with the further condition that he remain at ODP for treatment. And I'll point you, I think all the other cases he had were reviews, it looks like. So I'll point you on those also. His projected graduation from inpatient is July 30th, so I'd like to come back before then.
And this is a felony charge, Your Honor, and it may be one we're going to be looking at taking on to the grand jury.
Okay. Well, how do you want to proceed then? Do you want it sooner, or do you want to see what he does in treatment before you make a final decision?
We are going to go ahead and take it to the grand jury.
Okay. So we need to set within 15 days.
I'm here all the 7th, 10th, and 14th, so which I think are all the court dates in 15 days.
Let's do the 14th. July 14th for a preliminary hearing and pretrial and review of the other cases.
Just wait for me to log it, I'm gonna talk to you about it too. Thanks.
Anything else?
Nothing with the defense.
All right, July 14th will be the next one. He's ordered to remain in treatment.
State of Ohio recalls Jennifer Losey, case number TRC 22262, A and B.
Jennifer Losey. All right, it's an acceptable screen. So I'll just give you a new review hearing date. You need to finish up your community service and your fines.
I'm paying my fines off today.
Okay. Very good. And then finish up your community service.
Yes.
And you'll be finished. I'll set your next hearing for August the 7th. August 7th.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Ashley D. Adkins, case number CRB 23169.
Ashley Atkins is Attorney Roger Smith's case, pre-trial.
Judge, this is a Walmart case. I spoke with Mr. Heald. My client intends to enter a no contest plea stipulation of facts sufficient for a finding of guilt. I believe the state is going to recommend 10 days suspended, 5 days community service, $100 fine plus court cost, and the mandatory stay out of Walmart admonition.
All right, well, before I would do that, I wanted to do your, because that's my standard protocol, because so many people that shoplift at Walmart gets dirty. So it becomes a treatment case then. So go get a urine screen, let's see what it shows. I'll send you after I get the results.
State of Ohio versus Joseph Adkins, case number CRA 23260, CRB 23261, TRD 182412. Joseph Adkins.
Joseph Atkins is Mr. Smith.
Judge, this was a Walmart shoplifting with a drug charge also. He was at OVP. I've not seen him. I don't know if he's still there, graduated, quit. What's happened to him?
Well, there is a felony in here.
Yes. We were hoping to get some treatment and keep it here at least at one time, but I've had no contact with this gentleman for quite some time.
See, what the felony is 23260.
Possession of heroin, correct, Your Honor. Based upon the weight, it was charged as an F4.
Yes, I'm trying to find the complaint, and I don't see it. I guess I've got two files or something. Try to maybe. Mr. Field, do you have a copy of 23260? I do not.
I do, Your Honor. It's a fourth-degree felony possession of heroin, and it occurred at the same time as the shoplifting charge. and the heroin was found, and he was arrested.
It was entered incorrectly into the computer. What's the ORC number on it?
2925.11 AC6B.
Well, 292511 comes up as a line misdemeanor, right?
Maybe the complaint's wrong.
There are students.
Yeah.
That's the problem.
Should be in possession of drugs charge, right?
Possession of controlled substances. Here, I'll just bring it.
It's the same statute, Your Honor, I don't know why.
It is. It's just got a million subsections. Approach line.
Yes. Is this an extra copy? Okay. There's not a copy in the file for some reason. So it should be an F4.
Oh, sorry.
So do you want to take, are you taking this to the grand jury, or how do you want to proceed with it?
We would just ask for a warrant to be issued from here, Your Honor.
Oh, well, guess what? You can order the hounds released. Mr. Sowers has a bond.
Oh, good.
Would you like to officially have the hounds released?
I prefer that as opposed to one of the grand jury.
Okay. I will take a copy of the bonds and send it to Mr. Sowers. So there'll be a warrant issued today for failure to appear. And, well, this happened before. He failed to, May 26th, he showed late. June 20th, he failed to appear, had to do a warrant against Mr. Sowers. So,
He's not been real good about staying in contact with, in fact, he hasn't stayed in contact with Miles.
bond forfeiture, July 14th. So we need some adjustments with Mr. Atkins if he does come in.
State of Ohio recalls Ashley D. Adkins, case number CRB 23169.
Okay, it's acceptable screen, so we'll go ahead and do the same thing.
Thank you, Judge.
Anything you want to tell me, Ms. Atkins?
I can pay all the fines today.
Okay, on the theft offense, I'll impose a $100 fine and court costs, 10 days in jail suspended, order you to do 5 days of community service, and we have a community service program here at the court. You can talk to your probation officer about doing that.
Okay.
Your order to stay out of Walmart's, and 2 years of probation with a review hearing. Is that right? Or it seems like it's longer than that. it's a wrong date. It says October 27th. It should be further out. All right. October 27th will be your next hearing. It'll be a review. If you get everything done by then, you don't have to come back. It's a hearing to determine if you are making progress on your case. You'll need to meet with the probation officer, Mr. Major, before you leave today. His office to the left as you leave the courtroom. He'll give you all the paperwork. Everything I told you have to do is going to be on a judgment entry. He'll give you a copy of it.
State of Ohio versus Stephen M. Atkins in Lawrence County Jail, case number CRA 23393.
All right, Stephen Atkins. Is that you, sir?
Yes, sir.
All right, Mr. Atkins, I'm Judge Capper at Lawrence County Municipal Court in Chesapeake. Your arraignment hearing is being done by teleconference. You are appearing in the courtroom on a television line. And everything you say is being taken down on the record, so you don't have to say anything. If you make statements, they can be used against you. You have the right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove this charge beyond a reasonable doubt. And your charges were faxed down to the jail this morning at 10:16, an hour ago, so you should have a copy of the charge. Do you have a copy of the charge?
Possession of a controlled substance?
Yes, sir.
Yes, Your Honor.
All right. The charge is possession of a controlled substance that alleges July 1st, 2023 in Fayette Township. You knowingly were in possession of methamphetamine, a Schedule II substance, possession of which is a felony of the 5th degree. Maximum penalty, a year in jail, $2,500 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand your rights?
Yes.
Do you have money to hire a lawyer?
No, Your Honor.
Do you have a job?
No, Your Honor.
Do you have no income?
No, Your Honor.
All right, Mr. Smith, I'll appoint you.
Yes, sir.
To represent Mr. Atkins. What's the state's position on bond for Mr. Atkins? And I have an address of 4634 Pine Street, Ashland, Kentucky. Is that the correct address, sir?
Yes, Your Honor.
Your Honor, the state would not be opposed to an OR bond if it were accompanied by treatment at a drug and alcohol treatment facility pending our next hearing. This is the kind of case that we might consider leaving here if Mr. Atkins were to be, to take part in treatment and be successful, that we would agree to leave the case here and not take it to the grand jury.
Do you have a medical card, Mr. Atkins?
Yes, I do.
Is it West Virginia?
Yes.
I'm not sure who would be okay with that.
Okay, but you live in Kentucky?
Yeah.
Yeah.
How long do you live in
I
Kentucky?
guess for almost 2 years.
Are you still using your West Virginia medical card?
No, I need to get it switched.
Okay, so I was initially thinking ARC, since he's a Kentucky resident, but he doesn't have a Kentucky medical card. So who wants this challenge? You got any providers?
If he stays West Virginia, I can help him.
Okay. RRG. Have we got anybody from the QRT team here today? This is the kind of case I would like to use the QRT team on. Because we need somebody to run this guy, make sure he's doing what he needs to do. If he's going to do outpatient.
Mr. Atkins, when you're not in jail, what's your telephone number? You have a cell? You can't remember it? Okay.
If you got a contact person whose number you do remember, somebody close to you, where your lawyer can call
Yeah.
Okay.
Are you recording?
Yes, sir.
681.
681, okay. Seven nine nine.
1233.
Whose number would that be?
My sister's.
What's her name?
Stephanie Atkins.
Okay, well, let me give you a little primer on what's going on. It's kind of complicated legally, but you've probably heard, have you heard of a grand jury? Have you heard of a felony charge before?
Yeah.
Well, that's what you've got. You've got a felony charge. There's two types of criminal charges, misdemeanors and felonies. In our system now, what a felony means is you can go to prison. If you get convicted of a felony, you can go to prison on a felony conviction. On a misdemeanor, you can't go to prison. You can only go to the county jail for your sentence. You don't get to go to the big house. You've got a felony. So if you get convicted of this, the state of Ohio could send you to prison. Well, I've been down this road a few times, so I know what the state's willing to do. They're willing to not send you to prison if you will go to treatment and do well and get good reports and show that you're in recovery, that you're getting off methamphetamine. You're a young guy. What are you, 24? Just turned 24, right? Okay, well, if you keep using methamphetamine, we come back when you're 30, if you make it to 30, because here's the other thing. Now in our community, when you think you're getting methamphetamine, you could be getting fentanyl too, because they throw a little fentanyl on top of it. Even when they tell you they're selling you meth, it's got fentanyl in it a lot of times, and that's what's taking people out. 110,000 people in the last year died of overdoses, most of which are from fentanyl. Okay, so you're at risk. If you keep using, you're at risk. And methamphetamine of itself is bad. I mean, it's not going to, it's harder to overdose on pure meth, but the long-term effects are bad. I mean, it ages you, in 3 years, it's going to age you 30 years. It's not good. So this is an opportunity for you, one, to get clean, two, not to have a criminal record, because not only will they not take you to the grand jury and indict you and send you to prison, they'll most likely dismiss your case, so you don't even get a record. But you got to do your part. You got to go to treatment. You got to do what you're supposed to do in treatment. And if you don't do it, then you're going to leave this court. This is the misdemeanor court, so you're going to stay here, and I'm going to supervise your treatment as long as you're doing good. If you don't do good, then you're going to get shipped down to the common police court, where the judges down there could send you to prison. And it has happened. On cases like yours, people have gone to prison. So the best thing to do is do your treatment, do what you're supposed to do, get good reports, get your case dismissed, go on and have a good life, and get clean. Now, you may think, well, I'm living in Kentucky, so I'm just going to run back over there, and there's nothing they can do. You have a felony. So what does that mean? A felony means you can be extradited from any state in the United States will extradite you on a felony, which means send you back to Ohio. And most countries will send you back to the United States. So if you think, well, I'm just going to leave the country, you're going to have to pick a country that doesn't have an extradition treaty with the United States. And that's probably a place you don't want to live. So in other words, you're kind of boxed in. The best thing and smartest thing you can do is get on the program, do what you're supposed to do, get in treatment, get clean, and get your case dismissed. Are you willing to do that?
Yes, Your Honor.
Okay. Time is going to tell. But I want you to know what the possible consequences are. Because believe it or not, I mean, it seems like it's a no-brainer to do the treatment, but we have people that don't do it. They blow it off and they're like surprised they're going to prison. Don't be surprised if you go to prison if you don't do what you're supposed to do. This is, my saying now is it's not like 7th grade math homework. or I do it if I want to. If I don't do it, nothing's gonna happen to me. No, something's gonna happen to you if you don't do what you're supposed to here. So. And Mr. Smith can fill you in on that too. I think he'll.
I will.
Agree with what I've just told you. So.
Absolutely.
Let's come back in a few weeks, and how are we going to get you connected with him, Mr. Webb?
He can either contact our main facility, or he can have my, I'll get his attorney my personal number or card or whatever, and work through that way if that's easier.
Okay. Well.
He'll be inpatient treatment. He's the only bed I have, 60 days.
Okay.
Glenville, West Virginia.
Inpatient treatment, are you willing to do that?
Yes.
Okay. You want to just pick him up, can you pick him up at the jail then?
Today.
Or?
We won't have anybody doing anything until Wednesday.
Okay.
I'm literally probably the only person working today.
I'm working.
Well, I mean, if I come in, there's about 2 or 3 of us maybe working out there right now.
Okay, well, I think he can, I think that's the best idea, is you just pick him up Wednesday.
Okay.
I agree, Judge.
Okay, so you're going to spend the 4th of July in jail. That's not a great option.
Sorry.
But it's better than going to prison.
Am I able to be at work today and get there?
No, that's what I just told you. You're not getting out of jail until Wednesday. They're going to come pick you up Wednesday and take you to an inpatient.
What time did you need me to pick him up?
Whenever you can get there.
Okay, I'll be over in the morning, Wednesday morning.
He'll pick you up Wednesday morning. And then let's come back 17th?
July?
Yeah.
Yes.
You're here?
Yes, I can do that.
So what's going to happen, you're going to go to an inpatient facility, and you don't have to bring him back here, but I would like to have a report maybe on teleconference.
We can put him on Blue Jeans whenever you need to.
We'll put him on. So you're going to go to a facility, and I'll see you on just like I am now, and you're not going to be at the jail. So that'll be an improvement. Wherever you're going to go is going to be better than the jail. Right? So you'll be in an inpatient treatment program. I'll see you on a television screen on July 17th. And I'll make a $2,000 OR bond. Ordered, released to RRG. Any questions, Mr. Agnes? Yes, the name of the group is RRG. They've got offices in several locations. One's in Huntington. That's where the people you're going to be working with are from, but they're sending you to Glendale, West Virginia?
Glenville.
Glenville, okay.
There's
a college there, Glenville. Glenville State. Okay. Do what you're supposed to do, get your case dismissed, and get clean. That's your orders. That's what you need to do. That's what you need to focus on.
So I'll be inpatient until the 17th?
Oh, you're going to be inpatient a lot longer than that. 60-day program, I think it is.
Yes, sir. Thank you.
You're welcome.
Thank you, Judge.
State of Ohio versus Leah DeChambeau, case number CRB 23326. Leah DeChambeau.
Okay, this is set for a sentencing today.
Josh Hardy.
It's my understanding the state has some witnesses.
Your Honor, next at the jail is Christopher Love.
Okay, the jail will have Christopher Lowe. We'll get to you in just a moment, sir. We got a hearing here we're doing first. know you can find all.
Your Honor, if it pleases the court, I've had a chance to speak with the complaining parties here, and they've had some real concerns about the situation concerning Ms. DeChambeau's dog, because it's a pit bull, first of all, and I know pit bull owners think that those dogs are sweet and lovable, but they're scary to people, and they do attack people. And we've got a video here, if we end up showing this video, that shows the dog in their yard. So that was back in May. Ms. DeChambeau was here, I believe, in March of this year and had a charge involving the same dog, in which she pled guilty to that. And there was restitution because of the dog attacked another.
It attacked our dog and he got hurt trying to save our dog.
Yeah, so that, I mean, this is a serious situation. So now we have, I believe she's already pled guilty. The first thing we'd like to do is ask where the dog is now, because they don't know.
All right, Ms. DeChambeau, do you have the dog still, or?
Yeah, I do. That's good, I guess, if they're asking, because I know they've put up a fence and we have as well, to try and avoid any of those issues. So we have done that, and obviously there's not been any more situations. And also too, I'm looking to move as well, just because I feel like now it's kind of, even though there's dogs all over the neighborhood, I feel like we're kind of a target. So I'm looking at relocating as well.
All right. Does the state have a recommendation for sentencing, or you?
We're kind of, I'm kind of hunting for a solution.
Okay.
Because I know that I understand why Mr. Hardy would be very concerned about this situation. I would be too. I was hoping to find out today that the dog was gone. Fences are helpful, but that's hard to predict what could end up happening, because fences a lot of times have gates in them, or dogs jump over the fences. It's my understanding that the fence that's up is made out of chicken wire too, which I don't know how reliable that would be. Our recommendation is going to be, and I believe the court, we went through this with that horse case several months ago, where we provided some case law to the court about the fact that the court has the ability to order the sale of animals or whatever as part of probation if they are central to the reason for the charge in the beginning. So our recommendation would be 10 days in jail suspended, and in order for her to either get rid of the dog or move within a definite period of time.
All right, Ms. DeChambeau, what was your response to that?
That's fine. I was wondering too, I know last time they said, wanted to talk to the dog warden, because he came out and he even said himself that the dog's not vicious. He doesn't want to, do any issues, like remove them or anything like that. As well as had to contain multiple dogs in that neighborhood. Like when he was on my porch talking to me, there was like 3 or 4 other dogs that were running around. So I kind of feel like I'm being targeted. He actually had to stop and talk to those people as well. But like I said, I am trying to move anyway, so I'm not opposed to that.
When do you think you can move?
What is it?
When do you think you can move?
We're looking to trying to get out by the beginning of September, if not the end of August.
Does she have a prior record? Has anything been done on that? So the prior case was $23,160. Okay, you did pay that. Is there any, there's no restitution requested on this?
Not on this one. I believe it was the restitution paid on the last one. So there's no
She did pay
restitution.
restitution for.
Yes.
Yeah, sure, I did pay, and the dog, he was loose for a few minutes, but was contained, there was no issues. I believe even the landlord mentioned that Mr. Hardy told him that he saw the dog one day getting pet by a neighbor at the apartment complex. So he's not sure why he's being claimed as vicious, I guess, since strangers were petting him previously. But
Any response to what she said?
and Mr. Hardy came to our home in our driveway, and my dog was out there being held on a leash, and he literally laid there and looked at him. So I feel like if they were very scared and concerned, they wouldn't have barged onto our property, honking their horn and screaming and yelling, causing a scene, especially with the dog being outside. The dog didn't bark at him, didn't growl at him, nothing. He literally laid there. And the officer was there and was a witness of that too, so.
The dog is a dangerous dog because of the prior situation. The dog was, again, off of Ms. DeChambeau's property, so I feel like the charge itself is legitimate.
Well, she's pled guilty to it, so that's an admission.
And
An admission that the events of May 12th did occur.
I just want all the facts to be out there because I feel like a picture is being painted that I just set him out, let him go run the neighborhood, and he's attacking everybody, and that's not the case at all. So I just.
We had a prior conviction earlier in the year.
Yes, sir.
And now you've had this case, and.
Yes, sir.
So, I mean, there is that. I know you claim that other folks have dogs that run loose, and that may be true, but, you know, if you're in violation of the law, it's just like people on the highway, there may be other people speeding, but if you get a speeding ticket, it doesn't mean that you are not guilty because other people speed. You know?
I understand.
There is a leash law in Ohio. Sometimes it's not well honored, but you have to keep your dog on your property under your control. You're not permitted to let it run the neighborhood or go on other folks' property. They're not required to deal with your animal.
I understand.
Anything else, Mr. Reed?
well, I think Mr. Hardy would like to make a victim's statement to the court.
All right, Mr. Hardy, go ahead.
I just wanted to state, I don't have any animosity towards anybody, but when the first initial attack happened, it was a very vicious attack that attacked my dog. There was a lot of blood involved, and I know she thinks that we're not concerned, but my 2-year-old daughter even mentions the dog. There's the white dog out there. She's scared to go outside sometimes still. So we just want our family to be safe. It's nothing against them personally. There was blood all over my hoodie, my pants. My dog was very bloody. Her dog was bloody. It circled our dog. It circled our house after the attack. So I know that she didn't see it, but there was a more vicious attack than what she thinks, and we just wanted to be taken seriously. Not that we think there's anything, wrong with the people. We just want to be safe and, our neighborhood to feel safe. Our neighborhood did witness the dog attack as well, so it's not just us. We have several neighbors that witnessed it and had statements. So that's all I want to say. We're not saying that we're not here to attack her personally or anything like that. We just want to feel safe in our home. That's all.
All right. Anything else, ma'am, that you wish to say?
No, sir.
All right. I'm going to impose a $200 fine, since this is a second offense. I'll order you to pay the court costs, 10 days in jail. I'll suspend that on the condition that, one, you keep the dog up while you remain in the neighborhood, and that you either get rid of the dog or move within 90 days of the order today. And there'll be 2 years of probation, just to ensure that you do that. I'll set a review hearing for 90 days out so we can know if that's happened or not. So let's make that October the 6th. We'll do the review hearing at 9 o'clock. And I see a lot of people posting stuff in defense of pit bulls and so forth, But I also see a lot of pit bulls attack a lot of people. So I think they have a reputation, and have earned a reputation of being very aggressive. They're scary dogs. And if you want to own one, it's kind of like owning a gun. To me, it's like somebody walking around with a gun. You got a pit bull, I see people at the park walking with a pit bull. And it's almost like a threat. I feel take it that way. It's almost like a threat. Like if you come at me, I've got something that can attack you. So if you're going to keep one, you got to keep it up, and especially after it's already attacked another dog. The law provides you got to go the extra mile to make sure that dog's not going to get out and attack anybody else or another animal. So, you need to see the probation officer before you leave and get your paperwork, and be back here on October the 6th for a rehearing at 9 o'clock.
Okay, where's that?
To the left as you leave the court.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Christopher Lowe, the Lawrence County Jail, case number CRA 23299 and CRA 23398 A and B. Daniel Cox is on deck.
Christopher Lowe, that's you, sir? Okay, it looks like there's two matters here, 23299 and 23398. 23299 is an allegation that there's a warrant for you in another court. 399, okay. Yeah, it is 399. The outside of the file says 2, but the document says 3, so it's 23399. This is in Lake County here in Ohio, city of Eastlake, from the Willoughby Municipal Court. So I think that's up around Cleveland somewhere.
Yeah.
It's alleged that there's a warrant for your arrest there, and a summons from that court asking that you be sent there on the warrant. So under Ohio law, you have a right to what's called a Rule 4 hearing. That's a hearing to make sure you are the person being sought by that jurisdiction and that I should send you to that jurisdiction to answer on these charges. You have a right to have an attorney and to have one appointed to represent you if you can't afford one on this matter of the warrant from Willoughby Municipal Court. Now you've got a charge here also. 23398 A and B, and these were faxed to the jail at about 11 a.m. this morning. The first charge, 398A, is an allegation of receiving stolen property. It alleges that Christopher J. Lowe at Fayette Township on July 2nd did receive, retain, or dispose of property, and that's an automobile, a Kia Sorento, and it gives a VIN number for the vehicle. And it says that you either knew or should have known that this vehicle was obtained by a theft offense. So that's a felony of the 4th degree. Maximum penalty is 18 months in jail and a $5,000 fine. 398B is also receiving stolen property, and that's a license plate. So there was a license plate that was taken, and that, because it's a license plate, that's a felony. It's a felony file. Maximum penalty is a year in jail, $2,500 fine. Do you have the money to hire a lawyer, Mr. Lowe?
Do I have money for a lawyer?
Yes, sir.
No, sir, I don't.
Do you have a job?
No. I came down from Cleveland to be off, I was on in Norway, and I came down here, it's where I originally from. It's my hometown where I was born, and I came down here to get off with it. So I've been off with it for almost 2 weeks, going to the Comprehensive Treatment Center.
To which treatment center?
The Huntington Comprehensive Treatment Center.
Okay.
I go there every day.
Is that the methadone clinic?
Yeah.
All right, I'm going to appoint a lawyer for you.
Can I say, Your Honor, that the vehicle is mine. At first I was with the license plate, which I thought that it was my stepdad's license plate on the vehicle the whole time, and I couldn't get it. We got a title to me, but when this go get the registered, I couldn't register because there's a block.
Okay, I'm going to appoint you a lawyer. Mr. Morford's going to be your lawyer. He's here in the courtroom. He's heard all this. What's the state's position on bond for Mr. Lowe?
State would ask for a $5,000 cash and surety bond.
Okay, I'll set bond at, do you think you can post a bond, Mr. Lowe?
If it was a little bit lower, I mean, if it's low just a little bit.
What do you think you could post?
1,500 taxes. I mean, maybe, that's a lot, and, I am taking care of what I need to take care of, but I really am, so, if you know, it's a little bit, something, because that's not going to be $25,000.
Mr. Heald, what's the state's position?
Well, I mean, our position is the $5,000 cash and surety bond.
All right. I'll set it at 5,000 cash or surety, primarily because of this warrant out of the other jurisdiction. Yeah, this, I didn't read what it says the charges. I assume it is a misdemeanor since it's a municipal court also, but it's a felony of the second degree. So I think that's appropriate. And for a $5,000 signature, or 5,000 cash or surety bond, I take it that's a bond you don't think you can post?
No.
So we need to have a preliminary within 10 days.
Sir.
When did you come into the jail, Mr. Lowe?
Yesterday morning, like very early Sunday morning.
We need to do it next Monday.
So he's got a Rule 4 from another county too?
Willoughby County, Willoughby Municipal Court, it's Lake County.
Okay.
Yeah, I was
That's, he's from Ohio, right? That was up in Ohio.
Yeah, I was actually trying to get an ODP. That's what I was waiting at the Walmart for, and I was getting ready to go over there. But my husband was, I was trying to get an ODP, and I was ready to get a bed. But I was going to take care of that warrant. It's not. But I didn't know that it was there. You know, my girlfriend got choked a lot. She was driving the car, and I ended up fighting the guy.
Don't be talking, sir, this much more for your lawyer. I'm advising you not to be talking facts right now.
Okay, and you want to talk with him by telephone then?
Yes, Judge.
If the jail could hold Mr. Lowe out by telephone, Mr. Morford promises to call here shortly to talk with him about his case. And then, are you available next Monday?
I am, Your Honor. I've got a number next Monday.
July 10th will be the hearing, next hearing for preliminary on his charge here locally and the other charge also.
My bond is 5,000 cash.
5,000 cash or surety, you can use a bail bondsman. You want to talk to a bail bondsman?
Yeah.
Okay, we'll have one contact you.
Judge, I'll get in contact with Mr. Salvage. So
Right, thank you.
you can move on.
State of Ohio versus Daniel L. Cox, case number CRA 08425, and Reggie Krantz is on deck.
You, sir, are you Daniel Cox? All right, Mr. Cox, this was on a theft offense, and it looks like you never completed your sentence and missed a review hearing back in 2016. Do you admit or deny that?
That's right, sir. I moved to Florida, my wife has been through, and I stayed down there to get the one way there. And then since her father passed away, so we had to come back and help her. Mother tried to settle things, and then get back to Florida.
Okay, how'd you wind up getting picked up on this warrant?
I've been working for Bob Gleason over in Huntington. All most of the students are, they're off right now, so I reset his years for him. I was working late 2 nights ago, and I had my tail light was hanging down next to below where it's supposed to. And I pulled over last day, I won't control.
Okay. And some of what you owe is restitution, which you paid some on, but you didn't pay enough to even cover the restitution that you owed. Harold Maynard, $905 on a theft charge.
Yes. Like I said, I got a lot going on right now, and I hope to keep this one around here over the next few months.
Okay. Well, where are you living in Huntington now?
I don't live in Huntington, sir. I work there.
Where do you live?
I work for Bob Gleason.
Where do you live?
3940 County Road 29. That's by Vesuvius Lake.
Is that an Ironton address?
He Road.
You have a phone?
Yes.
What is it?
Yes. It's 740-981-0028.
280028?
Yes.
Gleason is your employer?
Yes.
Well, you owe this guy some money on this theft offense. Are you going to pay, or you just want to lay this out in jail?
They did it behind me. Mr. Mayor's actually a good guy. The reason that happens is they were actually Bill's Hauling Schools to owe me $2,800. That's why all this took place. Harold was just a manager at Spalding's courtyard. He went without charges. So that's how it's all went down.
Okay. Well, all I know is the order, you were charged with a felony theft. It was reduced to a misdemeanor. You pled to it. You agreed to pay $905 restitution. You paid some, but you didn't pay $905. And then you did show up for your review hearings and got a warrant outstanding. All right? That's the way it happened.
Yes. But sir, I'd like to just get it where I can come back out there and pay, and I can even pay 100 a month, so that means that in 9 months it's to be 100.
Okay, that would be wonderful. I'll send you to time served for contempt for not coming to your hearing before, and I'll give you a new review hearing of August 4th, so you got a month. And noting that you're promising to pay $100 a month. All right, that's at 9 a.m. on August 4th, which is the first Friday in August. You got to come to the court for a review hearing. If you don't show up, we'll do another warrant for you. Okay, you'll get out here shortly.
Thank you.
You're welcome.
State of Ohio versus Reggie A. Krantz, case number TRD 193235 and CRB 18516, CRB 1834. Cody Hicks is on deck.
Reggie Krantz. All right, sir, you Reggie A. Krantz.
Yes, sir.
Mr. Krantz, I'm Judge Capper. I'm at the Lawrence County Municipal Court in Chesapeake. It's alleged you've got warrants in 3 cases. CRB 1834 was a theft conviction from 2018. It's alleged you missed a review hearing September 2nd of 2022 on that case, and that you've done nothing on your community service and fines and costs that you were ordered to pay. Case number 18516 was a drug paraphernalia charge. It was also set for September 2nd. I'm showing you did nothing on it. 181303 was a license forfeiture suspension. You had just a fine on that. Nothing's been paid on it, and you missed your hearing September 2nd of 22. 193235 was a driving error suspension. Same thing. It was set for a review hearing September 2nd, showing that you had 18 hours community service and a fine. You've done nothing on it. Do you admit or deny you missed your hearing September 2nd of 2022 on these cases?
I admit I did.
Do you have an explanation for why you missed?
No, sir, I don't have a license. Well, I didn't have a license and stuff. I live 45 minutes away from Chesapeake. It was hard for me to get there. That's no excuse, though. I don't have a real reason.
Where are you living now?
I'm in Decatur.
Okay, well, you're in Lawrence County then.
Yeah.
Okay, well, this isn't the first time you missed a hearing, so
Right.
I'm going to sentence you to 5 days in jail for contempt. When did you come into the jail?
I came in Friday.
Okay, I'll give you credit. I'll give you credit for 3 days. He can be discharged on Wednesday, the 5th. So you get to spend the 4th of July in jail. And then I'm going to give you, I'm assuming you would prefer to finish this rather than just lay it all out in jail. I can amass everything into jail time. You don't want to do that, do you?
Well, I have a probation violation from common pleas. I'm going to be in here for a little while waiting on that.
Oh, okay. Well, maybe you will prefer to do that. Here's what I'm going to do then. Do you have a lawyer on your probation violation?
I don't know yet. I haven't.
You haven't appeared yet, so you're going to be in jail for a while. Let's come back then, because you're probably not getting out of jail anytime soon. I'll just set your review hearing for the 14th of July. I'll go ahead and do that sentence, but he's going to have a holder probably for common pleas, so he's not, even though my holder will be released, he'll probably still be sitting in jail. And if you're still there on July 14th, we'll readjust then. I'll see you like I'm seeing you now on teleconference and decide if I'm making any adjustment to your sentence. July 14th will be your review hearing. If you get out of jail, you gotta come to court my court on July 14th, or you'll get a warrant. And that's at 9 o'clock, July 14th. Okay?
State of Ohio versus Cody Hicks, case number CRA 23392, and John McCoy is on deck.
Cody Hicks.
Hello.
And sir, you're Cody Hicks?
Yes, sir.
Your charges were faxed down to the jail at 10:18 a.m. this morning, so you should have one in your hand now. Have you seen your charges?
Just possession?
Yes, sir.
Yes.
Okay, I'm going to go over it with you. First, I need to go over your rights, but you have a right to remain silent. You don't have to make statements. If you do, it's on the record. It can be used against you if you admit something. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove any charge against you beyond a reasonable doubt. You understand those rights?
Yes.
The charge against you is possession of drugs. It alleges that on July 1st, in Fayette Township, you knowingly obtained or possessed methamphetamine, a Schedule II substance. Possession of that substance is a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. You understand the charge?
Yes, sir.
You understand the rights you have?
Yes.
You have the money to hire a lawyer.
I'm sorry, could you repeat that?
You have the money with which to hire a lawyer.
No.
You have a job.
I have no company.
All right, Mr. Scott, I don't feel like I can appoint you since you're going to be gone. Certainly. So we're back to Mr. Steyer. Appointing Mr. Steyer to represent you, it's a felony 5 possession of methamphetamine. I've got to run on Kentucky people today. I've got a 4634 Pine Street, Ashland, Kentucky address for you. Is that correct?
Yes.
Do you have, how do you pay for medical services? Do you have a Kentucky medical card?
Yes, I have one here.
From Kentucky?
Yeah.
What's the state's position on bond?
The state wouldn't oppose an OR bond if it's accompanied by treatment at one of the local facilities.
I would be willing to do that at one of the local Ashland facilities. Is that what you were saying?
ARC. ARC is the one we use the most, and they have a representative here in court today.
Yes, I would be willing to do that.
Jeremy.
Are you going to release him, or do I need to call down to the jail?
Well, I don't know what, you want to do an assessment?
Yeah, that'll work.
Any input?
I'm here for a while, Your Honor. I've got a trial scheduled, so.
So what I'm going to do, Mr. Hicks, are you in relation to Ken Hicks? Are you in relation to Ken Hicks?
I'm not too sure.
Okay, I wouldn't be either, even if I was.
Yeah, I'm not trying to admit it.
I'm going to have a representative of Addiction Recovery Care, which is ARC in Kentucky. That's who we primarily work with in Kentucky, one of the ones. They're going to call, talk to you, and then after they do that, and your lawyer may want to talk to you in there too, so you may get in on that phone call. We'll have you back and we'll decide what your terms of bond are going to be. But generally, let me just say this. It looks like the state's offering you a treatment path. If you will go to treatment, they won't pursue a felony against you, which is a big deal. Because felonies you can go to prison for. And once you get a felony on your record, it's hard to get a job. It's hard to do a lot of things with a felony on your record. So this is a great opportunity. So you need to have the attitude, I want to do what I can do to get clean and not have a felony. That's a win-win.
I'm on board.
Okay. So I'll have you back after you talk to your lawyer and the treatment provider. You want the
Yeah, they'll probably.
Court's file? Okay.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus John D. McCoy, case number CRA 23397 A and B, and CRB 2697 A and B. Nathan Ralph is on deck.
Sir, are you John McCoy?
I am, sir.
I'm Judge Capper, judge at the Lawrence County Municipal Court where your charges are filed and where your hearing's taking place, and you're actually appearing in the court today on a television monitor where we do this hearing. It's all being recorded. Whatever you say is going down on the record. So that brings me to your rights. You don't have to say anything. You have a right to remain silent. If you do make statements and admit something, the state of Ohio can use it against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove charges beyond a reasonable doubt. You understand those things?
Yes, can I say something before we begin?
Yes, sir.
I admit, I am,
Okay, well, you're in the right place because we're going to try to get you some help. And I think will become apparent as we go along in this hearing. All right, you've got a charge of possession of heroin. 397A alleges that at Union Township on June 30th, you knowingly were in possession of heroin, Schedule 1 substance. Possession of that is a felony in the 5th degree. Maximum penalty is a year in jail, $2,500 fine. 397B alleges the same time and place you were also in possession of methamphetamine. That's a Schedule 2 substance, possession of which is also a felony 5. Maximum penalty, a year in jail, $2,500 fine. Then it's alleged you got an old case from 2020. 20697 is the case number, and Mr. Morford was the attorney on this, and it looks like it's still pending case, and let's see what it was. Well, see, there was a protection order. And it looks like he went to treatment before. So let me just tell you what your charge was in that case. I can't. There's a lot in your file. I'm looking for the charges in your file. Criminal damaging, 697B, and domestic violence. Those are the old cases that are still pending from 2020, and Mr. Morford was your lawyer at that time. So, he's here today, probably on the phone, talking with another defendant. So that's a complicating factor because, yes, this is your old client, John McCoy.
Yes,
He had, in 2020, a domestic violence and a criminal damaging charge. He was going to treatment then, and then he's been out of pocket, it looks like, since, well, not that long, April 28th was the last hearing it looks like he failed to appear for, and now he's got a new charge. It's a possession of heroin and methamphetamine, felony 5 charges, and he's in custody, and I'm going to appoint you on the new cases, and you're already on the old case. And then what's the state's position on bond for Mr. McCoy?
Well, Your Honor, there is also another pending case from 2022, and that's criminal mischief, and that...
What's the case number?
22 CRB 426.
Okay.
So that happened while he was already involved in the 2020 case for which he had been in treatment for.
It looks like he wasn't served on that. I'm looking at the... Does it look like he ever appeared? Looking at the computer, I don't have summons returned by certified mail not served.
Yes. he was given, on April the 3rd of 2023, he was given a $1,500 cash or surety bond.
Okay.
And,
He appeared on the other case and got served.
yes, so, and then on the 7th, April 7th, he got a $1,500 OR bond, and he was supposed to go back to Riverside. And then, on April 28th of this year, he failed to appear. But he had been away, and a bench warrant had been issued for him on May the 27th, 2022. He got a bad report from Riverside at that point, and he was positive for meth at that time. So he's built up quite a history of noncompliance. Probably a good thing that he's back in custody again, because doesn't appear that he's done any better. But given the fact that and by the way, on the 2020 case, he missed court several times. There were bench warrants issued October 18th, 2021. February 1st, 2021, he failed to appear. So there's cause for great concern about his well-being. So at this point, unless he were going to be released with an ankle monitor, we would be opposed to an OR bond or anything like that. We would ask for at least a $10,000 cash.
Well, I'm going to leave that call up to you. You can take it to the grand jury, or would you want to try again with an ankle monitor? I'm okay with that. That was the ante if he goes with an ankle monitor.
Please.
Well, we could do that too.
I don't know if there's any available. Here's the thing you need to understand, Mr. McCoy. If I put an ankle monitor on you and send you to treatment, and you cut the ankle monitor off, it is guaranteed, the common pleas judges have set this as their standard because they want to discourage people from cutting ankle monitors. You are going to go to prison for 3 years. 3 years.
I will not cut it off.
Okay. Well, I have people tell me, you know, it's funny, I tell this every time, most people don't cut the ankle monitor off because, I mean, that's a lot. 3 years in prison is a lot. But a certain, maybe 10% do. They'll cut the ankle monitor off and they go to prison for it. I've got people in prison right now that I've given this speech to, and they said, no, I'm not going to cut the ankle monitor off. And then they do. And then they go to prison. Yes, sir?
Would I be allotted time, like, with the ankle monitor on, to get myself together at home?
No. No, you wouldn't. I don't know. I don't even know if there's an ankle monitor. That's the first thing we got to see, if there's an ankle monitor available.
I believe so, Your Honor.
You're in luck. There is an ankle monitor available. Well, I don't know that you're going to go to OVP. Who wants to take it? Okay, this is going to be longer term than 30 days. It's not going to be any 30-day program. So this is like your last chance. You mess around and messed around and haven't taken it seriously in the past. This is the last chance, and if you don't do it now, I'm going to send you on down to the common pleas, to the grand jury. You're going to get indicted, and then you're going to have a really good chance, especially with this history if you mess up. So you got a really good chance of going to prison. And if I were you, I would do what it took not to go to prison. What's that? Okay, well, I think that's I think that is the right response. Some people apparently aren't that scared of it because they do things that bring it on, knowing that it's going to bring it on. So, Mr. Morford, what say you?
Judge, he needs treatment, and I'd like to see him get back into treatment, get himself back, and I'd like for you to understand, John, Judge Capper's a man of his word. You show him effort, and that you're buying into this, and he will see that your case stays here with the agreement of the state. But if it goes to Ironton, you're looking at much bigger problems than you have here. Go to treatment, do what you know you need to do, and show God Capper you're buying into the program, and you are going to get clean.
Now, the other question is, can we get it? I don't think we can probably get an ankle monitor today, can we?
We won't know until after 1, Your Honor.
Okay.
They're after lunch.
I figure they're out.
Ironton City Center's closing at noon, Judge, so.
I'll do a poll. How many people think they're gonna come back? My money's on no. They're not coming back after lunch. July 3rd, March 4th of July.
Yes, sir.
I don't think it's gonna happen. So probably Wednesday is gonna be when he gets his ankle monitor. But I'll release him to Bethesda whenever he gets an ankle monitor on. If it happens today, great. If it doesn't happen, it's gonna be Wednesday.
There's no way to go home and get my stuff on there.
No, there's absolutely, you asked that once before, and I think I said no, so quit asking. You should be lucky that you're even getting, this is like the third or fourth chance you've had. I believe in second chances, sometimes I believe in third chances, but I think you're beyond that. $2,000 OR bond. And let's come back on 17th. So you know how this works, because you did it before. They're gonna come back, they're gonna tell me how you're doing. You should not even spit on the sidewalk, because you're on thin ice. You gotta do everything they tell you to do, when they tell you to do it, how they tell you to do it. No back talk, no attitude, no messing with the other people, no wanting to fight with the other people, no barking orders out to the staff or the other people. Do you understand that?
Yes, sir.
Okay. Okay, July 17th will be your next hearing.
17.
Yes, sir. We'll see you then.
Do you know when they'll be here?
It'll either be this afternoon or Wednesday morning, depending on when your ankle monitor is available. That's the best I can tell you. I'm betting it's going to be Wednesday morning. If I was a betting man, which I'm not. July 17th will be your next hearing.
State of Ohio versus Nathan Allen Ralph, case number CRA 23391, and Latrice Robinson is on deck.
So are you Nathan Allen Ralph? All right, Mr. Ralph, I'm Judge Capper at Lawrence County Municipal Court, and you are appearing in the court on a television monitor, and everything we say is going on the record and being recorded. You don't have to say anything. You can remain silent if you wish. You have a right to have an attorney, to have one appointed if you can't afford one, to have bond, and to make the state prove any charges against you beyond a reasonable doubt. Now, your charges, the reason you're here, it's alleged that there's a warrant for you in another jurisdiction.
Yes, sir.
Seneca County, I don't even know where that is. Seneca County, Common Pleas Court.
Yeah, it's about 3 hours away, up north.
Okay. We're getting a lot of those today. So you have a right to what's called a Rule 4 hearing. The hearing is not to decide whether you did or didn't do the violation that Seneca County is saying. The hearing is to decide, is this really the Nathan Allen Ralph that they want? Should I send this guy up there all this way away from Lawrence County?
That's me. Yes,
Okay, so you can waive a Rule 4 hearing. You can say, yeah, it's me.
It's 100% me.
Okay. And what they're saying is, I'm reading the warrant, it's saying you violate conditions of supervision in that court, and therefore they're asking you to be returned there. So they don't tell me what kind of bond they want. So I'm going to set a bond. If you can post it, I'll let you go turn yourself in. If you can't post it, can you post any bond?
No, I can't post no bond.
Okay. Well, that makes it easy.
Yeah, I would assume they would come get it.
They will. I assume they will too. I'm going to set bond at $10,000. I'm going to say you can't post that. So I'm ordering to be posted immediately, which you can't do.
Right.
And then I'm going to give them a time in which they have to come pick you up.
All right. They're going to notify today, or?
Yes, the jailer who's listening in, go ahead and notify Seneca County. He's available to be picked up.
Okay, good. Thank you.
And because there's a holiday in there, I'm going to give them through I'm going to give them a week, so that's July 10th.
All right.
So if you're still in our jail, hopefully you won't be, on July the 10th, I'm going to see you again in a hearing, and I'll decide then whether I should release you or give Seneca County more. If they call and beg me for more time and give me a good reason why they couldn't get here, I may give them more time. Usually they pick them up in the time frame I give them.
Yeah, I assume they'll probably be here in a couple of days.
Yeah, you think they probably really want you bad then, huh? You think they'll come down here?
Yeah.
Okay, I'm giving him a week, and he's going to be on my docket at 10 o'clock. I'm giving them till 8 a.m. next Monday to pick him up. If they haven't, then I'll see you then by teleconference, and we'll talk about it again, and I'll probably have the prosecutor call up there and see, what's the holdup? Why haven't you guys been down here to pick him up? And we'll figure it out.
Yeah, they have 2 road drivers there still.
Sounds like you know the place pretty well.
Yeah, I've been locked up a lot.
Okay. Well, sorry to hear that. Okay. Next hearing is July the 10th at 10 o'clock. Hopefully we won't have it because you'll already be up north somewhere. What's the county seat of Seneca County? What's the county seat of Seneca County? Where's the courthouse in Seneca County? What's the town?
Tiffin.
Tiffin, okay.
Yeah.
Another one of those Ohio places.
State of Ohio versus Latrice Robinson, case number TRD 221281 A and B, and Christopher Lowe is on deck for recall.
You know, Mr. Hill, nobody here says Ohio except when they do that cheer. They say Ohio.
Oh, I'm fully aware of that. And actually, it's more like Ahia, like A-H-I-A.
Put an A on the front too?
Oh, yeah, Ahia. Ahia.
Okay, ma'am, are you Latrice Robinson?
Yes, sir.
I'm Judge Capper, Lawrence County Municipal Court, and it looks like this must be a Rule 4 hearing.
Yes, sir.
They didn't give me a Rule 4 form. Case number. No, it's a case here. I was thinking it was in Franklin. I think she lives in Franklin County. I think the case is from here. Case number is 221281. Okay. So it's not Rule 4. It's a case here. It just looks like you didn't show up when you were supposed to. Ms. Robinson, it's alleged that you had a citation where you were cited into court May 17th of 2022. No, I'm sorry. You were cited in court May 24th of 2022 for traffic court. Your incident allegedly happened May 17th of 2022 at 12:53 a.m. in Fayette Township, where you were driving a vehicle without a valid operator's license. That's unclassified misdemeanor, maximum penalty, 500 hours community service, $1,000 fine. And it's alleged you were speeding, driving 75 in a 55 zone. Maximum penalty for that is $150 fine. Do you understand these charges?
Yes, sir.
Do you understand your rights? You have the right to remain silent. You don't have to say anything. You have a right to have an attorney. These are not jailable offenses, so you can't get one appointed. You can hire one. You have a right to bail and to make the state prove charges beyond a reasonable doubt. How do you wish to plead to these charges?
I plead guilty.
Okay. Do you understand a guilty plea means you're admitting the charges are true and you're waiving your rights to have a trial and a lawyer?
Yes, sir.
The officer wrote, defendant was traveling west on US 52, could tell visually that they were exceeding the speed limit. Radar check came back at 75 miles an hour and 55. I contacted the defendant. She said she knew she was speeding and she did not have a license. Computer check confirmed no license. And then you did come to court when you were ordered to.
You're right about that. I was actually incarcerated too, since December the 5th. So like, I think I went on like a little run, and then I was incarcerated.
And then how did you get her? Well, I see where you were incarcerated in Franklin County, but that wasn't until December of 2022. I mean, that was a long time after this. Have you been in jail in Franklin County since December?
Yes, sir.
Okay, so they transferred you down here when you finished your sentence there.
Yes, sir.
Anything else you want to tell me about your case?
I'm not able to post bond.
Well, you pled guilty, so you don't need a post bond. I'm just going to sentence you.
Okay.
Anything you want to tell me before I sentence you? So obviously, you still don't have a driver's license. You've been in jail 6 months in Franklin County.
I plan on getting one of them.
Well, everybody does. Pretty rare that somebody tells me, no, I'm never going to get my license back. Everybody says, yeah, I'm going to get my license back. Okay, on the no operator's license, since you've been in jail for 6 months, I'm sure you don't have a lot of money laying around, so I'll give you a $25 fine and court costs. Now, the speed offense, and explain to me, you know you don't have a license. It's 1 o'clock in the morning on US 52, and you're driving 75 miles an hour and 55. What were you thinking?
I was anxious. I had just launched out from Western Regional Jail, and the people where I was driving, they let me drive. So that was the reason, and I do apologize, but I'm scared straight in here. I never made out here.
Okay, well, I see, I don't know if I can say this, but I will. I don't see too many women doing this kind of stuff, but I see men doing it all the time, especially young males. 1 o'clock in the morning, US 52, which everybody knows is crawling with state troopers. And what are they looking at for 1 o'clock in the morning? Drunks. And you're going 75 and a 55, and you don't have a driver's license. That is not very smart. Usually that's the dumb stuff that young males do. Females don't usually do, they think through things, thinking, you know, if I don't have a license and I'm driving 75 and a 55, I'm probably going to get pulled over and I'm going to be found out that I don't have a driver's license. Young males think, oh, I can do this, I'll get away, I'll see them, they'll never catch me. So, use your brain a little bit. You shouldn't be driving. If you are driving, you don't have a driver's license, shouldn't you be doing the speed limit? so you don't get pulled over.
Yes, sir.
Some things in life are pretty easy if you just use your brain. And think about it. What could happen if I do X, what's going to happen? Okay. So you haven't been out of jail since December?
No, sir.
And you live in Columbus?
Yes, sir.
You got any kids?
I got 2 daughters, 7 and 8.
Where are they?
With my women.
Okay. She's probably ready to kill you.
She is. I haven't talked to her since I've been here, so it's kind of hard.
You have any other holders? Is this it?
This is.
Okay. I'll give you a $50 fine on the speeding, 20 on the no operators. Get out of jail, go back to Columbus, start using your brain, get your life in order, get your driver's license, take care of your kids. Think about what you're doing.
Can I get jail time? Because I'm not going to do that.
No, I don't want you in jail. I want to get you out of jail. Here's what's going to happen. I'll give you a final pay date. So you got till October the 10th to pay this. If you don't pay it, we're just going to notify the B&B, and they'll suspend you from even getting a license. You won't be able to get a license because you didn't pay your final court costs. So
Yes, sir.
you don't need to be in jail any longer. You've been in jail long enough. Get home, take care of your kids.
Yes, sir.
Okay, that's all.
State of Ohio versus Christopher J. Lowe, case number CRA 23299 and CRA, 23399, and CRA 23398A and B. And Shelley Rodriguez is on deck.
Your Honor, I asked for this to be recalled because I looked at this report more closely, and it appears that the stolen, or the items that have been stolen that were in Mr. Lowe's possession actually are 2 license plates.
Okay.
And not a car or a
vehicle.
license. So what we would do, since he's got this Rule 4 matter from Lake County, we're covering all of the northern Ohio counties,
Yes.
all of Lake Erie frontier there.
It is. They all want to come here now for some reason.
We would just nolly these charges and let him go, if he wanted to waive, to go back to Lake County. We would.
Okay, so that's 398 A and B is going to be nolly, which means dismissed, Mr. Lowe. And then maybe we could, okay, I think you're the one, are you the one that told me you could post a $1,500 cash or surety bond?
Yes, Judge.
Or are you going to negotiate down from that now?
You got it down to 5.
I think you said you could do 1,500, didn't you?
I was trying to get something lower. 5,000 is all on the last person.
Well, I'm willing to go to 1,500 now. That way you can post the bond, I'll let you go turn yourself in. That's a lot better than getting drug up there by the scruff of the neck by a sheriff's deputy, isn't it?
Yeah, that helps.
Judge,
That helps. Thank you.
his mother has been in touch with Gary Sowers, the bail bondsman. And I
So
talked to
Gary's not going to be
Gary.
happy with me.
He didn't indicate what
Okay.
they're going to do, but he is aware that he wants to post a bond and will be in touch with Mr. Lowe.
I'm going to make it 1,500 since the seriousness of the charges here, well, they're gone. So I'm just going to make it a $1,500 cash or surety bond. That's about as low as we go. So $150 probably will get you out if your mom guarantees it. And then you've got to go turn yourself in up in Lake County.
Yeah, I understand. Thank you.
When do you think you could post the bond? How much time do you want to post the bond?
I'm hoping today.
You think you can do it by 4 o'clock?
Is it what, 12:30?
12:30?
I should be able to, yeah.
Okay, and you're waiving your right to a Rule 4 hearing and agreeing you'll either go there by this bond, or if you can't post bond, then I'm gonna order them to come get you. But you're pretty confident you can post the bond?
Yeah.
Okay, let's set it for next week.
Yes, sir.
I'm giving you until Monday morning of next week, July the 10th, to turn yourself in before 8 o'clock, because we want to call up there and verify you're already there. So if you're not there, then there's going to be a problem, because I like to tell the bail bondsman to go track you down, and he will.
No, I understand, thank you.
Are you certain that you understand that you have to report to Lake County Court?
Or show up back here and explain why you didn't get up there.
I was on my way up there anyway, if I could get OBT, I was going up there.
It's the Willoughby Municipal, it's the Willoughby Municipal Court that is looking for you.
Yes, yes, sir.
Okay, we're going to send the Rule 4 waiver down for you to sign. If something happens, you don't get up to Lake County, you got to be here July 10th at 10 o'clock. You understand that? Here at the court in Chesapeake.
Okay, yes.
Which is back toward Huntington from where you came, right? You've been staying in Huntington.
Yeah.
State of Ohio versus Shelby Rodriguez, case number CRB 23396, TRC 23816, A, B, and C.
Okay, Shelby Rodriguez, that's you, sir. Can you hear me, Mr. Rodriguez?
Yes, Your Honor.
Okay. I'm Judge Capper at the Lawrence County Municipal Court, and this is your arraignment hearing. You're appearing in the court by teleconference. It's all being recorded. You have a right to remain silent. You don't have to say anything, but if you do make statements, it's all going on the record and can be used against you. You have a right to have an attorney, have one appointed if you can't afford one. You have a right to bail, to make the state prove any charge against you beyond a reasonable doubt. Do you understand those things?
Yes, Your Honor.
Okay, you're charged with okay, I don't have the case number. The TRC is TRC 23816. That alleges on June 30th at 9:22 p.m. in Peary Township, you were driving at a speed of 68 in a 55 zone while you were under the influence of alcohol or drugs. It's alleged that you submitted to a urine screen, and I don't have the results on that. It'll take several weeks to get the results. The maximum penalty on the operating a vehicle intoxicated charge is 6 months in jail, $1,075 fine, and a 3-year license suspension. The minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. You're also charged with driving out of your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. On 23-396, it's alleged that you, on June 30th, also had children in the vehicle while you were under the influence. So that's a first-degree misdemeanor. Maximum penalty is 6 months in jail and $1,000 fine. Do you understand these charges?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
How do you wish to plead to these charges? You can plead guilty, not guilty, or no contest. Which plea do you wish to enter?
No contest, Your Honor.
No contest means that you don't want to fight the charge. You're agreeing that if I believe, the court believes that the state possesses sufficient evidence to convict you, that I can find you guilty without a trial and lawyer. So it doesn't have that, there's really not much difference in this case, since there wasn't a wreck or anything, between this and guilty. Do you understand that? You're probably going to be found guilty if you enter a no contest.
My apologies, Your Honor. May I say something?
No, just tell me what plea you want to enter. If you don't want to enter a no contest plea, you want to enter a not guilty plea.
I want to enter a not guilty plea, Your Honor.
Do you wish to have a lawyer appointed to represent you?
Yes, Your Honor.
Do you have a job?
Yes, Your Honor, I have a good job.
What do you do?
I work over at Home Builders Supply off Dietrich, and it's connected to the church which was open, Your Honor.
Are you paid by the hour?
Yes, Your Honor.
How much per hour?
$17.50,
How many hours a week?
40 hours.
Do you have any children you're supporting?
Yes, Your Honor, I have custody of my oldest son. I'll let custody of him.
So you're making about $36,000 a year gross, is that right?
Yes, Your Honor. I haven't missed much work yet. I'm still making out my job. I'll leave out you.
Okay. And is there just you and your son in the household?
And our large puppy, Your Honor.
Okay, well, that doesn't count. So, actually, you're making too much money for me to appoint a lawyer for 2 people in a household. So, I'm going to enter a not guilty plea for you. And you have an Ironton address.
Yes, Your Honor.
So I'm going to let you, unless the state objects to an OR bond. Is there any reason to object?
No, we don't object.
I'm going to let you sign a $1,500 signature bond. What that means is I'm going to let you sign a piece of paper that says, I promise to come to court as ordered, and if I don't show up, I understand I'll get a warrant for my arrest, plus when I do get arrested, I'll have to pay $1,500 as a penalty for not showing up. So as long as you come to court, you don't have to post any money.
Yes, Your Honor.
You understand that?
Yes, Your Honor.
So you're guaranteeing your own appearance.
Yes, Your Honor.
So I'm going to give you a hearing date. Is your work schedule Monday through Friday?
Yes, Your Honor.
Which one of those days is better, or does it matter between the two?
It doesn't matter, Your Honor. This is a big priority.
Yeah, it is, but I want you to keep your job. So if one day would help keep your employer happy over another, I'll work with you. I'm going to make it Friday, July 21st. So that, and this will be the only notice you get. So remember that date. It's the 3rd Friday in July. You have to come back for a hearing, or come to, well, in a sense, you're here now. Your image is here, but you have to be here in person at the court in Chesapeake. You know where that is?
Yes, Your Honor.
Okay.
No, Your Honor, but I'll find it. I'll find it, Your Honor.
It's on County Road 1, not far from the 6th Street Bridge in Huntington, about a mile and a half, 2 miles, something like that. July 21st for pretrial at 10 o'clock. And I'm going to put down that you will hire an attorney. Do you have any questions, sir? Okay, you'll get released this afternoon on your own recognizance.
State of Ohio, we're finished.
Oh, good, finally. We're finished at the jail.
State of Ohio versus Bridget A. Ellis, case number CRB 19820, CRB 18235, CRA 18171, CRB 16133.
All right, Bridget Ellis is here, this is on arraignment. Looks like you had a review hearing back in March that you missed, and there's been a warrant outstanding. Did you get, she got picked up this morning? Or?
She did, I just picked her up.
Okay, I think what makes sense is for you to do a urine screen so we see where we are. Let's do a urine screen, then we'll decide what we need to do after that.
State of Ohio recalls Stephen Dodgen, case number TRC 23457, A, B, and C.
All right, Mr. Dodgen was going to get me a date, and it looks like it's July 21st.
That's correct, sir.
And defendant waives time constraints until then. May have met to the entry. And there is an order, and it is in the motion, it says time's waived. So we got a faxed in motion for continuance, which I'll grant, and reschedule this for July 21st for a pretrial at 10 o'clock.
Thank you, sir.
You're welcome.
State of Ohio recalls Michael B. Anderson, case number CRB 23394.
This is Mr. Stratton's case, and we will let Mr. Stratton and Mr. Anderson speak.
Yes, Joe.
And the state was going to try to get a hold of Portia.
We were unsuccessful contacting the alleged victims.
Okay, so let's just come back quick. It's my understanding, as I remember, she's staying with your mom, so there's no reason you have to go there, is there? You can just stay away, and we'll come back pretty quick.
Yeah.
The main goal here, Mr. Anderson, is I don't want there to be an allegation that something else happens while we're out of court. So let's just have a cooling off period, come back pretty quick for the next hearing. What's your availability, Mr. Stratton?
Anytime, Your Honor.
Waiting for the court.
Well, either next Monday or next Friday.
Either.
So you have a preference? He's
Next
working.
Friday would be better, Your Honor.
Okay. That's the 14th. July 14th for pretrial at 10 o'clock. There is a protection order issued, and he can sign a $1,000 OR bond. He was.
You signed it.
Not guilty plea is entered.
Thank you, Your Honor. July 14th, okay, appreciate it.
State of Ohio recalls Cody Perky, case number CRB 23319. Mr. Scott's case.
All right, we need Mr. Scott, he is here. Cody Perky for pretrial.
Ellen Mines, Judge. I tried to get a hold of Lorraine. That was unsuccessful. I imagine that case manager is enjoying a long weekend. I imagine between now and Friday I'll be able to make contact, in which case I've discussed it with Mr. Stratton. He's agreed to step in and fill in my place, and I believe we get this resolved on Friday.
Mr. Stratton.
Yes, Your Honor.
Do you know that Mr. Perky can be here then, or?
It's my hope that between now and Friday I get in contact with the case manager and get something set up. It'll be by Blue Jeans most likely.
Is he in a treatment facility, or?
He's in prison.
Oh, he's in prison?
Yeah, he's ODRC.
All right. I forgot that, okay.
He's not having a good time, Judge.
All right, so we'll set it for the Friday, the 7th, for pretrial.
Thank you, Your Honor.
You're welcome.
I'll get you. All right.
State of Ohio versus Stephen Carmen, case number TRC 222038 A and B.
Stephen Carmen is Mr. Stratton's case set for pretrial.
Your Honor, this is a high first OVI. We're going to plead today. We'll plead no contest to the charge, asked it be set for sentencing.
Okay. Is he doing some treatment or what's going to happen?
He will be in some treatment, yes, Your Honor.
Where is he going to go?
What was the name of that place? Is that Tri-State Family Connections? This is now. River Hills Prevention, is this it?
No, this,
Oh. Who's the intensive outpatient crew?
I don't know, I have to find that out.
Okay. Who have you spoken with?
I just got this morning.
Okay. Your Honor, we haven't settled on somebody just yet, but he'll be in some place
Well, let's
before
see,
sentencing.
let's try to nail that down. He lives in Ironton, correct?
Yes. Yes, Your Honor.
You have how do you pay for medical service? Do you have a medical card?
Yes, Your Honor.
Ohio medical card?
Yes, Your Honor.
Okay, and this is alcohol related. Mended Reeds, can you work with him?
Yeah, I can really do an assessment.
Okay. All right, I'm going to have you talk with the Mended Reeds representative. And then let's come back, and he's entering a guilty plea today.
Yes, we're entering a guilty plea, yes.
Do you agree with that, Mr. Carmen?
Enter a guilty plea, you agree with that? Yes.
Yes.
Okay, are you sure?
We talked about this. This is exactly what we talked about. Entering a plea, set it for sentencing.
For like an illness, is that what you're
Yeah,
thinking?
yeah.
Yes, Your Honor.
Do you want to talk with your lawyer some more before we finalize things?
I'd like to, just.
Okay, I'll let you talk with him. Let's do this. Let's do a little mini assessment with Mended Reeds too, and then we'll come back.
Yes, Your Honor.
So talk with the Mended Reeds representative, talk to your lawyer, then we'll come back and finalize at least this part of it.
Thank you.
Go out there and talk to that guy. I'll be out there in a second. Okay.
State of Ohio versus Nicholas Rouse, case number TRC 23722 A, B, and C.
Mr. Stratton's case, pre-trial.
Your Honor, I sent you a update with negative drug screens from his health recovery services. Besides that, we do not have the discovery on this case yet, so I do ask this be set for another pretrial, but that's just a status.
Okay. When do you want to come back? Do you have a preference?
2 or 3 weeks, Your Honor.
How about the 24th?
Yes, that'll work.
July 24th.
July 24th. Okay.
Pre-trial, 10 o'clock.
Just make sure they fax me another one again. Okay, yeah. All right, very good.
State of Ohio versus Roberta M. Abbey, case number CRB 23270 A and B. Mr. Morgan's case.
This is Mr. Morford's case.
I'll suggest that. That sounds like a good plan. So, Your Honor, I've spoken with the young ladies here who are the alleged victims, and things have evolved a little bit, I think, in their situation, and they do not want protection orders anymore, and they do want to be able to go back with their mother, but they themselves take part in counseling at NECO, and they would like their mother to take part with them and do some family counseling, which sounds very positive to us, and we would be willing to put the case on a 90-day continuance and see how things go, and hopefully be able to dismiss the charges if there aren't any further problems, and the counseling is
And set for October 2nd.
Is that a Monday?
It's a Monday.
Okay.
Is that better?
Yeah, that's good.
October 2nd. Be dismissed then if there's no further problems, and do you want costs paid? Or
Yes.
with costs? Is that agreeable?
Thank you, Judge.
You're welcome. Okay, I think it's a great idea to go together.
Think of Mints and Fences that have.
Thank you. Thank you, Your Honor.
You're welcome.
State of Ohio versus Aaron Cottrell, case number CRB 23352.
Mr. Morgan's case, pre-trial.
Right here.
Let me see. This is a reward theft.
Yes.
Your Honor, do you have a report from the counseling center?
I do not.
I've been there 7 days. It ain't from you guys. You guys didn't refer me.
I do not have a report from the counseling center. We can try to get one. We don't have it yet.
Yeah, I can have my case manager give you a report or whatever you need.
Somebody here from the counseling center?
My driver, she's out there.
Your Honor, this is a Walmart theft case, and we're happy that Mr. Cottrell is in treatment. That's always a good thing if a person recognizes that and does it and tries to do better. And if that were made part of a disposition in this case, we would be all in favor of that. But we're just, if he were to enter a guilty plea, we would just be asking for a suspended jail sentence and some community service and a small fine.
Okay.
Willing to finish the treatment at the counseling center?
Yes, I am. Can I do the community service there where I'm there?
You can do it in Portsmouth or?
Well, I'm in treatment, in-house,
I understand that.
where we do cleanup and stuff.
You mean like in the facility?
Yes.
Usually we don't do that, but I thought you did it, you're within walking distance of Portsmouth Municipal Court there, so you can do it there.
I'm not allowed out right now.
Okay.
I'm in-house treatment.
We would be willing to recommend to the court that in lieu of the community service, that he complete the counseling.
Okay.
We'll take that.
All right, anything you want to tell me, Mr. Cottrell?
No, sir.
Okay, I'm going to reduce his fine to 50, since he's in inpatient treatment, doesn't get much money. $50 fine, court costs, 10 days in jail, what's up to jail? 30 days in jail suspended, since he's in treatment. I'll suspend it and the community service as long as you complete treatment at the counseling center.
Okay.
No community service required. I'll set a review hearing for you for October the 27th.
Okay, so as long
I
as.
need a report from them that you completed treatment then, and a order you to stay out of Walmart's.
Okay.
That's the hardest part.
Come back. Okay.
State of Ohio versus Aaron Sloan, case number CRA 233688 and CRB 23369.
Mr. Morford's case, preliminary hearings and pre-trials, and she's at Harker.
She was assessed, Your Honor. There were a few scheduling conflicts with getting her in, but she did get in and get assessed, and she's set to begin treatment with us.
And you're starting Wednesday, looks like.
Yeah, my first counseling, but I've already started.
Okay. So this is going to be outpatient?
Yes.
Now, if the QRT team is here now, this is one that I would like to refer.
They're here now.
Are they still here?
Macon was here just a minute ago,
Yeah,
so.
if QRT is here, come into court. There is an OPO.
Additional.
I don't see her in the court, Your Honor.
Okay, I'll send them a text, we'll see if they come back. I had two earlier that I called for, and they weren't even here yet. And then they showed up and had one they wanted to do, and I said no, and they left. If that person was inpatient, we don't need QRT on inpatient people because they're getting monitored by the treatment provider.
State of Ohio recalls Bridget Ellis.
Wait a minute, I'm not done with this
Oh,
one.
okay, I'm sorry.
Just have a seat, right here. We're not finished with this case. Okay, so she's going to be outpatient. I'll try to get QRT in to monitor her. I don't know if that's going to work or not, but we need reports, obviously, from ARC. And
I have Megan and Aaron's contact information. I can put them in touch if need be.
okay. Let's set it for July 24th as the next hearing.
State of Ohio recalls Bridget Ellis, case number CRB 19820, CRB 18235, CRB 18171, CRB 16133.
Okay. Negative screen. Good. Well, what's your explanation for missing your hearing back in March?
I figured it was March 8th, maybe.
6th.
Yeah, I thought it was May, so I actually just mixed them up.
Well, it's not May now, it's July. So, where have you been? You still in South Point?
Yes, I'm helping my daughter take her little grandbaby. She works at night.
looks like you just have fines to pay. Community services, man. I mean, if you forget when you're scheduled, you know where the court is, you know we have telephones. You can actually call on the phone and ask when's my next hearing. You have access to a computer. You can go on that way. There's no excuses for missing your hearing. And you need to come in on your own rather than get drugged in here. Now, I'm very glad you're clean still. So, you're in a way lucky you didn't get drug in and sit in jail for a while before you had a hearing. Okay, you guys start taking care of this stuff, and if you can't pay, you can do community service. Are you working?
No, right now.
Okay, so there's no reason you can't do community service.
Right.
When do you need a weed eater? Can you run a weed eater?
Yes.
Tuesdays and Thursdays, Your Honor.
Okay, I want you out here Thursday.
Okay.
No excuses.
Yes, sir.
No grandbaby excuses, okay?
Yes, sir.
Somebody else is gonna have to watch them.
Okay.
And then, so that's July 6th. I want to see you back on a review hearing August 4th. That's, you're back to monthly basis, so August the 4th, first Friday in August at 9 o'clock. Okay, she can be released.
State of Ohio versus Terry Aldridge, case number CRB 33304, excuse me, 23304, CRB 23544A and B.
Your Honor, after discussions with the state and just taking care of discovery on this matter, I believe this is one I want to look at for a possible motion to suppress. So if we could set this on perhaps the 31st, and we would waive time to accomplish that. I've got several of these sort of lined up at the same time, so I want
So
to...
that'd be a pretrial?
Pretrial on motion, yeah.
So you'll get the motion filed by when?
I would aim for about for the 24th, if that'd be okay with Mr. Hill, because we wouldn't be expecting to hear it that day. Give him a chance to take a look at it before we came in.
And are you gonna, is this gonna be a shotgun, one of those things that mentions every possible thing? Because that's just, here's the motion to suppress is supposed to be, where you look at the evidence and you say, oh, there's a problem with this specific evidence, and I want to raise that before trial.
Right.
I don't want any more of these shotgun motions that raises every possible thing. As one court of appeal said, when you object to everything, you object to nothing. So if you look at the case and there's a specific problem with evidence, raise that specific problem. Not, the last one we had talked about stuff that wasn't even in the case. It was obviously a motion that came from some seminar or something. It had nothing to do with, well, some of it had nothing to do with the facts of the case. And that's not what these motions to suppress are supposed to be for. If that's what happens, then I'm just going to let the state put on basically a very broad, generic form of their case, and then we're not going to do it again. We're not going to do that at trial, because they've already proved their case once. Okay, and that's not, I'm not just getting on you because you weren't the one that did it, but I want all the lawyers to know that. Motions to suppress are supposed to be problems in the evidence that you've actually looked at and think, oh, well, the calibration wasn't right. I want to talk about that. Or there was problems with the reason they pulled him over. Not like every possible thing that's in the case. Okay? July 31st for a pretrial motion. Motion to be filed by July 24th.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Mary Hampson, case number CRB 23321.
Your Honor, this matter is one where she is in treatment with RRG.
I have the report, have you seen it?
Okay, I have seen it.
So, it sounds like she's got some work to do.
That'd be our position as well. Also, she is participating with the QRT team, and Megan reports that she is complied on that end, met with her today. So at this point, we would just ask to continue.
That makes me wonder about the QRT team. Because the report says she missed 3 sessions, shouldn't they know that?
I provided her with a copy of the report.
Okay.
So if we could set this back, we would waive time constraints to continue to accomplish that.
Mr. Hill.
We're in agreement with that, Your Honor.
She's indicating she was sick and made those sessions up.
Okay. Time will tell. But it was mentioned in the report,
Right.
that's why I mentioned it. I think the term that they used was semi-compliant. That wasn't a full-throated endorsement of what you've been doing.
I've seen worse.
True. August 4th or 7th?
Either of those are fine with me. Is Friday or Monday better for you?
It doesn't matter.
Then whichever's better for the court, Your Honor.
August 7th for pretrial.
And text, let Megan know about that date.
Okay.
State of Ohio versus Cameron
Thank you.
Weaver.
You're free to
Case
go.
number CRB 23284.
Your Honor, if I may, I had note Mr. Weaver was forced, he was going to do 30 hours community service before the sentence, and he has done 30 hours of community service.
Very good.
Your Honor, this is a matter that happened at school, and we discussed, contacted the school personnel and got their agreement on what we wanted to present to the court. We wanted Mr. Weaver to do the community service, and then because he intends to join the military, we had agreed we would dismiss the charges if he did the community service. So that's what we would do today, seeing how he's finished the community service.
I think I may need to recuse myself because I have some knowledge on this. It's not quite the same. So I'm going to recuse myself and let another judge be assigned by the Supreme Court.
Do we need to get a date today, or how does that work?
Can't get a date till we get a judge assigned. So I'll have the clerk do that and get another judge assigned. So you'll be notified as to the next day.
Thank you. Stick around. I'm going to come talk to you later on after. I didn't know who was here with you. I'll come talk to you after. Just stick around for me.
State of Ohio versus Jennifer Brown. Case number TRC 23649, A and B. Jennifer Brown.
Jennifer Brown, you said you would hire an attorney, have you done that?
Yeah, I've not had a chance to yet.
It's been a month.
My husband was in a motorcycle accident. I was off work for 3 weeks.
You were or he was?
He was.
What about you?
I've been working, but
What do you do?
I work at Southern Hope.
Okay, so you're the only income coming in?
Yeah, right now,
How much do you make?
$13.50 an hour.
You have children?
Yeah, one.
You're qualified for a court-appointed lawyer, do you want one?
Yeah.
Okay. Mr. Morford, I'll appoint you. July 21st.
Good here, Judge.
Yes.
Next hearing is July 21st, 10 o'clock.
0525. 0525.
Thank you, Judge.
State of Ohio versus Brittany Smith, case number CRA 23275, CRB 131153 A and B, and CRB 131057.
Have you read the report?
I have not seen it.
You don't have a copy?
No, sir, the only thing I have is the complaints. But they're saying that you need to move to inpatient. Because of appointments.
I just missed Friday, was all rescheduled it for tomorrow.
What do you want to do? And that's what they're.
I don't want to do inpatient.
That decision rests with that man home.
What says the defendant?
Each thing. Judge, she is reluctant to go to inpatient.
Well, let's do this. Why don't we do a urine screen today, and if she's dirty, she goes to inpatient. If she's clean, she stays outpatient. You okay with that?
Yes.
Go do a urine screen.
Your Honor,
Thank you, Judge.
there's something else we need to address, and that is that this is a felony theft charge, which we intend to keep a felony. So
So you want to take it to the grand
it
jury?
needs to go to the grand jury. And
Okay. And she has an old, the other cases she have are old.
Yes, Judge, I believe she.
Theft and the theft. Two
Oh,
old
you-
theft cases from 2013.
Owes you money on them, Your Honor?
Yes, so, I mean, are you wanting to nolly this to the grand jury now, or how do you want to proceed with it?
she may want to waive to the grand jury. I don't know if
She's got no harm on that.
I will waive.
Okay, so she'll need to sign a waiver, and let me try to explain this to you, and you can talk to Mr. Morford.
Okay.
I don't know if the state was ever going to keep it here, but anyway, they're not keeping it here now, so you're going to go down to the common police court. You started treatment, but you didn't get a very good report. They're recommending you go inpatient. Now, my suggestion is you do that, because you're going to the next level. They're going to take your case to the grand jury. You're going to get an indictment, which means you're going to, felonies are so serious that we can't just let the prosecutor decide whether somebody gets charged with a felony. Your peers, other citizens have got to look at the evidence and say, yeah, that's what an indictment is. Other people vote and say, yeah, I think they probably did it. So that's an indictment. You're going to get an indictment. And then you're going to go in front of one of the common police judges. And you go to prison. So do you want to walk into the felony court with a recommendation that you go to inpatient treatment that you refuse to do?
Right.
No, that's not a good posture to be in. You're already got 1 foot, you've already messed up a little bit. I don't know, maybe they would have kept it here, maybe they wouldn't, but they're sending you on down now. See if Mr. Morford doesn't agree with me. I'm giving you some free legal advice. The best posture you could go in to the common police court, because it's going to take a month or two before you ever appear down there for you to get indicted. Come in with a good record, not this bad record, a good record where you did what you were ordered to do or supposed to do, got clean, because you know what? They got so many people that are dirty that they can send to prison, that they'd be happy not to send you to prison if you show them that you're clean now. I mean, that's my take on it. Maybe I'm wrong. I don't think I am. But you got to get serious. You can't like HA this. You know, you're on the edge of going to prison. So you better get scared. I would get scared a little bit about this and do what's necessary.
You understand what he's telling you? Get in.
Okay, so now what's happening is you had a right to a probable cause hearing here in this court. It's called a preliminary hearing. And it's just kind of like the grand jury. It's just for me as a judicial officer to look at this and say, yeah, there's enough reason to send her on to the grand jury, hold her for this charge. You're waiving that, and the reason you're waiving it is they can just dismiss it and take it directly to the grand jury and let you out float around without a bond. But you've got a signature bond. That's the best bond you can get. You didn't have to post any money. So you're going to keep that bond. Now you have to show up in common pleas when you're asked to on the indictment. The problem is going to be they may appoint Mr. Morker as your lawyer, and they may not appoint him as a lawyer, and the lawyer you get may have no idea where you are, or how to get hold of you, or how to get you into court so you can preserve your bond. So if it was me, you have access to a computer?
Yes.
The clerk, Michael Patterson, has a website at Common Police Court. I would go on there every week and check my name to see if I've been indicted. And then when I get indicted, I'm going to show up and turn myself in so that I don't get a new warrant and have to post a new bond and have to go over to that jail or whatever they're going to do to you. Okay? So there's some free advice. Hope you'll take it to heart. Hope you get clean. Stay out of jail. Stay out of prison. Do what you need to do to make that happen. Now, you still have these two old cases with me that you've never taken care of. So you're still going to see me on those. You go $315 on case number 131153 and $85 on 131057.
I have done some community service too.
You can do community, I don't see that you have any community service ordered, but you can do community service to work on your fine.
Okay.
I'll give you another hearing date, August 4th, for review. At, let me see.
Put your telephone number down there, please.
Well, you know what? You've got a bond up, so it's going to be a sentencing hearing. So it'll be at 10 o'clock, August 4th, sentencing hearing. You got a bond up through Mr. Sowards now. So if you don't show up, he's going to come fetch you.
Okay.
10 o'clock, August 4th.
Okay, thank you.
Okay, good luck.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Cody E. Hicks at the Lawrence County Jail, case number CRA 23392.
All right, Cody Hicks is back on teleconference. Can you hear me, Mr. Hicks?
Yes, sir.
And your lawyer is Mr. Steyer.
Yes, Your Honor.
He's here in the courtroom. You all had a chance to talk?
Yes, he is willing to cooperate with treatment. ARC has approved him for inpatient treatment. They can pick him up tomorrow.
The closest bed we have for him is in Pikeville, Kentucky, but I mean, that's 2.5
I hear
hours.
Pikeville's beautiful this time of year.
Yep.
And it gets you away from some of the bad influences you might have living around here. No, there's no possibility.
No, they'll give you an OR tomorrow to go with, well, you're not going to be actually coming.
No, they'll have
Yeah.
somebody from the facility there.
Someone from facility will be there about 2 o'clock to pick you up.
Tomorrow?
Yes.
On 4th of July?
Yep.
That's amazing. Okay. You're lucky because we've had several others that are going to treatment and they're probably not getting out to Wednesday. So You are a lucky guy.
How long is this agreement, man?
Till you're clean.
That's not, I'm just curious.
And you'll come back, I'm gonna monitor your progress, and as long as you're doing good, you're gonna stay here. If you mess up, I can send you down to the common police court on a felony. You have a felony pending, but I'm gonna keep it here and monitor your progress. Do good, you'll never get indicted, you'll never get a felony, you'll never go to prison. In fact, you can get it dismissed probably if you do really good. But if you mess up, I mean, best case scenario is you get your case dismissed and you get clean. That's a pretty good result all the way around. Everybody's gonna be happy with that. You mess up, you get indicted, you get convicted of felony, and you go to prison. That's a pretty bad result.
Yeah, no, that was what I had.
You don't want that, right?
Yeah, that's right.
Okay, well, act like it. Do what you're supposed to do, when you're supposed to do it. What'd I say? Well, that McCoy guy I knew, like, don't bark out orders to the staff or the other, don't fight with the other staff members or the other patients. Don't leave.
Thank you, Your Honor.
You're welcome. And we'll see you the 24th, July 24th. And he can appear by teleconference.
Okay. I'm here that day, Your Honor.
July 24th will be your next hearing, and there's a time waiver till then. Okay, you got a great chance here to get things turned around. Do it.
Thank you.
You're welcome.
Thank you, Your Honor.
Now we are finished at the jail.
State of Ohio versus Stephen Carmen on a recall, case number TRC 222038 A and B.
Your Honor, he spoke with minute reads, and we are still going to plead guilty today and set up for sentencing.
Okay, and you got something set up to start with him?
Yes, he's going to get a hold of me Wednesday.
Yes, Your Honor, we are currently working on getting him a full assessment schedule.
Okay. All right, so I'll accept your guilty plea and set this, that case number is 222038. And set this for a sentencing.
Sometime in August would be better, Your Honor, maybe first week.
I was thinking toward the end of the month.
Or towards the end of the month.
Let's do the 24th. Are you here the 24th?
Yes.
July 24th. At least the first time I like to see him pretty quick.
Yeah. And if necessary, we'll send
Somebody
for another
starts
sentence.
counseling.
Okay.
July 24th, 10 o'clock.
Let me know how that minute reads goes. Okay.
State of
Let me
Ohio
know how
versus
Thursday
Gary
goes.
Dale, case number CRB 23323 A and B. Gary Dale.
Thank you.
See ya.
This is Mr. Stratton's case, and it's set for a pre-trial today.
So, this is what you did. You did it here. I wasn't taking the minutes, correct.
He ran from the police. I'll put the DV on a 90-day continuance, but I'm going to have to agree to this. We can do 60 days, 57 suspended.
Your Honor, just ask this be set for another pretrial. I think we got half of it resolved, but not the other half.
Okay, for some reason I had 6/12/23 on here for a motion. Is that not right?
No, that's.
And that's not my handwriting. It's looks like it was.
Oh, Your Honor, that's for the modification of the protection order, which I believe has already been done.
Oh, okay.
Yes. I'm
So we
sorry.
can scratch that out.
And, Your Honor, I'd like to make our position clear on this. We are aware that the alleged victim does not want us to pursue this, the domestic violence case. However, the other case the obstructing case is the kind that we take very seriously. That he ran away from the police and tried to avoid being arrested. And so our offer, in order to resolve that case, is 60 days in jail with 57 suspended, where he would be required to do 3 days in jail. We would put the domestic violence case on a 90-day continuance and dismiss it with the payment of court costs at a later date if there weren't any further problems. So that's our position on it.
Your Honor, I asked to be set for another pretrial so I can discuss this with my client. I want to just clarify a little bit about what the prosecution, because I think that's a mischaracterization of what she said.
It's a misunderstanding by you.
No, it's a mischaracterization, because in her written statement, she said my client did nothing wrong and I wasn't taking my mental health medication, okay? So she, in writing to the prosecutor, said that my client did nothing wrong that night. So to say she doesn't want to pursue it, yeah, but she also written out that it didn't even happen. So, but I asked to be set for another pretrial, Your Honor.
Was she saying that the night didn't happen? That's,
Exactly.
that's,
Well, I mean, she's either lying then or lying now. So,
well, that's happened before.
yeah, I know. She's done this multiple times.
I'm looking at the affidavit.
It's okay, but the way to dismiss the DV, but we gotta talk about this obstruction because it's led into something additional.
Okay, well, review the affidavit, so it's a little different story there. So,
Yeah, I understand. Couple weeks, it'll be all right, Your Honor. The 24th.
How about the 24th?
Yes.
17th is pretty booked. July 24th for pre-trial, 10 o'clock.
24th, okay. Then we'll talk about this, we'll have to talk about it.
State of Ohio versus Darrell Bone, case number CRA 23318.
Okay.
This is Mr. Scott's case, it's set for preliminary hearing today.
That's correct, Your Honor. The state and I discussed it this morning, Your Honor. This is a unclassified felony for dumping. Mr. Bowen's made some significant improvement to his home, making sure it's staying cleaned up. I believe it was the state's position that if we kick this one down the road a little bit, make sure he's still doing those things, and it maintains clean, and it'll be resolved in place.
August 14th, then?
August 14th.
Case is continued to August 14th, or it's going to stay here rather than go to the grand jury, so there's a time limit.
I have that prepared already, Your Honor.
Thank you. 10 o'clock, August 14th.
See you then.
State of Ohio versus Alec Douglas, case number CRA 23259.
I have all my time papers still after that. I had to come.
Mr. Steyer's case.
Your Honor, I'm sorry?
I said she's here.
Yes, Ms. Douglas has a case that is concurrently going on in the Common Pleas Court, and it's her intention, we have a report as well.
Permission to approach, Your Honor.
Yes. Okay, it says she's compliant. with
Yes.
the Things working on.
And it is Ms. Douglas's intention to enter Judge Ballard's drug court, I think earlier, is it last week or sometime?
It was the 22nd.
Okay.
You've already started.
Before you can start, you have to attend a session and just observe.
Okay.
She has done that. We have court again with her in Common Pleas in a week or two, at which point we're expecting we're going to divert her into the drug court. And it's our intention that this matter also join in the drug court. So for that reason, what we'd like to do today is waive preliminary hearing to maintain the bond and ask the prosecution to make a note to prepare a bill of information to present to me and to the court in Ironton on, we find out when, for sure, our next.
It'll be July the 12th.
Yes, July 12th is our next hearing, so we'd like to have a bill of information, on this matter, ready to present to that court on that day so that we can wrap those matters into the drug court.
Okay, so you're gonna sign a waiver that just says you don't need to have a probable cause hearing. You agree that your case can go to trial?
Yes.
You're gonna put this in the drug court?
Yes.
Both cases will be in the drug court?
Yes.
Yes,
And I'll put it, I think I've already done this. I've already talked to Judge Ballard about you, so, and I'll put in another good word for you. You gotta do your part.
Just sign your name. It's, I don't think at this point it probably matters, but her name's misspelled on the style of the case. It's Allie K is one word, and it's Allykaay.
It's always misspelled wrong.
I don't think it matters necessarily, just state. Yeah, may I approach?
Yes. Okay, you gotta do your part. I gave Judge Ballard a good recommendation on you, and so I thought you were very appropriate for the drug court. But you gotta do the work when you get in there, okay?
Yes, sir.
All right.
Thank
Good
you
luck.
so much.
You're welcome.
Here, thank you. Pretty good.
Thank you, Your
Thanks.
Honor.
Thank you.
Okay, we have sentencing.
State of Ohio versus Keith W. Cooper, case number CRB 21288, TRC 21121, A and B. Keith Cooper.
Your Honor, if I may, he was on the teleconference this morning. We told him he had to be here in court today, and he did not appear.
Because he'd also failed to appear for community service when I had ordered him.
He had been put in the back once, Your Honor, and he was ordered to be here that Friday and did not appear that Friday.
So that makes it easy. He'll get a warrant. Does he have a bond up?
He told us he was out of town, and he said that he would be at the next court day available when he got back.
Judge, he has contacted my office with the same thing, that he was in Massachusetts working.
He does have a bond. So, yeah, I'll let Mr. Sowers know. So I suggest he get in here Friday if he doesn't want to get arrested.
That
He can
would be-
avoid Gary till Friday.
That would be my message, Judge.
January the 19th of 23. So warrant today. And bond forfeiture, what do we set the other one, July 14th? This has happened, April 21st, we had a bond forfeiture then. At least it was said, I don't, you probably got him. Looks like he's had a lot of problems getting in here. When he's supposed to.
Thank you, Judge.
You're welcome.
State of Ohio versus Terry J. Krantz, case number TRC 23311, A and B.
No, I didn't. If you go first.
This will be good, right?
Yeah, for sentencing.
Everything's been clean. I can't complain.
got another one Thursday, yeah. He just checked for me, it's 11:30 on Thursday. Yep. Trust me, I don't know anything to do. You too. And I was still waiting for the Social Security, still going through, so I was still waiting to match. And I put in your eyes and then you wrote anything to them. We don't have, I couldn't pay my employee insurance, so they canceled it, so we're saying, I could drop my kid. So, I'm just waiting for the Social Security stuff.
Okay, it's a good report.
We were just discussing that, Judge. She's doing well. I think she's fine in the program.
Yes.
But not finished?
No.
Okay. Continue to monitor, so what everybody's agreed.
My recommendation.
It's okay with me.
And she'd already entered a plea, right? So we're just.
Correct. She's in sentencing phase, Judge.
Another month?
Yes, I'm here August 4th or 7th.
Let's do the 7th.
Okay.
August 7th for 6th.
Is it Monday or Friday?
That is a...
It's a Friday. Friday? Okay. Oh, it's a Monday.
So the 4th is a Friday, yeah.
Okay.
State of Ohio versus Nathan Wicker, case number TRC 222401, A and B.
What you're doing.
Okay.
So Mr. Wicker's reached out, his girlfriend's having a baby, so that he's not in attendance, but he has completed our program.
Yeah, he graduated the 28th. I got a text from Derek. I would just ask Judge a couple weeks. We're also in the sentencing phase. He's done everything he asked. Apparently, his girlfriend or wife is having a child this morning.
Let's do, are you here the 24th or 21st? Either one.
Of July, the 21st and 24th, I'm not. 21st, I'm here.
21st? Yeah. Let's do July 21st for Mr.
That'd be a good girl.
Perfect.
Thank you, Your Honor.
I'll let him know.
Yes. State of Ohio versus Austin Pritchard, case number CRA 181233 A and B, CRB 181234 A and B, TRC 183525 A and B.
Mr. Pritchard is at Orange County Recovery.
Yep.
Yes. Okay, it's good. You got a job lined up at Engine Inc.?
I was going to go back there, but I ended up going to McGinnis.
Okay.
Yeah.
Is that better for you?
Yeah, I think so.
So, you gonna be working on the barges or what?
I'm gonna be welding on dry dock.
Okay. Well, if you ever need a job at Superior Marine, I can probably get you one there. They're always looking for welders.
I worked there 3 years right out of high school.
Okay.
Yep.
So it looks like all you've got here is you need to complete your old OBI. And it looks like you got things going the right way.
Yeah, been pretty good.
So, what's the plan? I know you're in sober living now. How
Yeah.
long you got to stay there?
Until they let me go.
Till they make you go?
Yeah, yeah.
There's no definite discharge date right now. He has spoke about being interested in going to independent living just to continue to build with his family while he's got sober support around him and everything.
Okay. When are you starting it again?
I started Friday, last
Oh, you
Friday.
already started?
Yeah.
Okay. You paying anything on your fines then?
No, I haven't got a check yet.
Okay. All right, well, I'll just set your next review here. I'll give you a little more time to get something built up. Let's set it in August. Does it matter if it's a Monday or Friday?
No.
No.
Not matter, no.
Let's make it August 14th.
Thank you.
You're welcome.
Is this back to review or?
We'll keep it, he has a bond up, I think. Yeah. So it'll be a sentence.
Sentencing today.
I'll set it as, you don't have to be here till noon.
Okay.
Go work it again till noon. Be here at noon.
All right, thank you.
You're welcome.
State of Ohio recalls Clarence J. Falk, case number CRB 04578 A and B.
Okay. This was a review hearing today, looks like, on an old, very old case. You did some community service since the last time. Can you pay anything on your fines today?
Well, I can't. I mean, my wife got sick, so she couldn't work for a couple of weeks, some of it on the income, but I was hoping to utilize like the community service to help me pay on my fine.
Well, you had 60 hours to do to begin with, so when you get that finished, if you want to keep doing more,
I thought it was.
we will.
I thought it was. I'm sorry to interrupt. I thought it was 36.
Your Honor, I would have to check where was he on the review docket?
Yes.
Yeah, he's on review. Let me,
Yes,
I can go back and check the judgment entry. It's 60 hours is what the judgment entry said back in 2004. You had 60 hours of community service.
His file should be updated if it was the review docket.
You've done 30. I've shown that you did 30 hours of community service, still have 30 hours left. After you do that 30, if you want to do more, you get, for every 6 hours, you get $50 credit toward your fines.
Yes, sir. I know I'm not really in a good position to ask for a request where I wasn't here this morning, but I was told that you could do community service hours at the Recovery Point Cafe. And no.
No. Whoever told you that was wrong. We never given anybody credit for that.
Okay, yeah, there's somebody told me. I just wanted to check.
Maybe it has a different court in mind. I don't know, but it's not this one.
So I have 60, not 36.
You had 60 initially, and you've done 30, so you got 30 left. So I'll set your next hearing for August the 4th, 9 a.m.
State of Ohio versus
Thank you, sir.
recalls Brandon G. Helton, case number CRB 2318, TRD 213585 A and B, TRD 213053 A and B.
Why didn't you do the community service I ordered you to do? Why didn't you do the community service I ordered you to do? That's not a good answer. You got a better one?
I have it scheduled where I can start doing 2 days this week, and I schedule all 2 days next week.
So when are you telling me you will be here for sure?
Wednesday, Thursday this week, Wednesday, Thursday next week, and then the Thursday after that week.
You got that down?
Then I'm not sure how many days I have, so I always schedule the 5 all.
Well, let's see. There's 30 hours, there's 5 days. That one you did. And 12. So that's 7 days. You got 7 days of community service. Okay. I mean, I don't like putting people in jail, but if I give you the chance to do community service rather than go to jail and you don't do the community service, there's really not a whole lot of options in between. It's either one or the other I got to do. So you got to do this. Okay, so Mr. Cooper's going to track it. If you don't show up for any of those days, then boom, it's gonna be jail. Okay? Be a man of your word. You said you're gonna do something, do what you say you're gonna do, when you say you're gonna do it. Okay, I'll release you. Have a good time with your family over the 4th, and your next hearing is August 4th for review at 9 a.m. You're welcome.
State of Ohio versus Kimberly Thompson, set for trial, case number CRB 23177.
Mr. Stiers' case. Case number is CRB 23177. Assault, this is the charge. The state ready to proceed?
We are, Your Honor. If I may, could I have just a few moments to speak with the alleged victim?
Sure. So I'll take a short recess. Let me know when you're ready to start, and we'll come back in here. I'll meet with my volunteers while we're doing that. Court's in recess.
Don't move forward. That's fine. That's fine.
Good, how are you?
Hey, Luke.